বলবেন না?
আপনি কি বলুন?
বলবেন না?
সিনিয়র লোক।
সেই জন্য বলছি। মানে seeking leave to file a appeal without 35 days.
When was the order?
Order passed on 25th. Urgency is this matter. The recruitment of the primary teachers have been started. It will finish on 9th.
Leave grant.
Milord, the same prayer, Milord. The order has been passed on 7th of November 2025. When the matter has been taken up, Milord, order has been given to produce the records on the next day. When I have seen in the Milord the server copy that the Milord the order had been Milord by dint of the order the writ petition has been disposed of. Next day I went to the court. I have mentioned the matter. Court taken up the Milord the server copy of the order and assured me that Milord the order would be revised. But that has not been revised. Subsequently, next day I Milord, mentioned the matter. When court stated me that Milord, this is my specific order, order will not be changed. So that's why there has been a delay in preferring appeal, Milord. And 7th of November 2025, order has been passed. We have
The order that was passed, the petition was disposed of.
disposed of. But in open court, when the learned Milord government pleader was there,
No,
in
no.
his presence, direction was given to produce the records. But
Then
I was under an impression that that has been erroneously gone down. So I went over
when
there.
did you mention 7th? If the order was passed, when did you?
Next day, immediately thereafter, when I have seen after 3 days, when I have noticed in the server that Milord, this order has been
Then
passed.
what happened? Did his lordship say?
I have handed over the server copy of the honorable court. The honorable court
That
told
was done when? That was when?
that
We are after a month, na? You are
no, not the after a month. On 7th of November 2025. Today is the first.
7th of
November 2025.
7th.
7th of November.
10th of November.
Yes. 7th of November
Have you
2025.
applied for certificate copy?
Certificate ko apply kore.
আজকে apply
No, today they will apply.
To apply and come and tell us tomorrow. Yes.
For notice, the other side mentioning one group 8 application for inclusion in the list.
Which year?
2024.
Must have been heard earlier.
Yes, it was
What
heard.
directions were there for
Direction
evidence?
was there, that had been complied. Exchange of ABDBs did complete.
Lordship, may I have Lordship kind leave to mention one matter for inclusion in the list, Lordship. Lordship, I am the TIC. I filed a writ petition. I am a TIC of a girls' school. I have filed writ petition because there was several
Hearing matter.
hearing
The
matter.
hearing
No,
of-
here this is the first time it will appear. It's a motion.
Application.
No, Lordship. It's an appeal. First time it will appear. I am prayed for a stay of the order passed by the writ court.
Have you filed that application?
Lordship, I have filed everything. It was supposed to appear on 27, but it is not appearing.
কেন ওই filing এ যাবো?
Of a writ petition where the writ petitioner's case is that she was working in a non-government institution,
Appeal hearing.
not appeal hearing. It has come as application for. I've already
Fresh
served
application.
fresh application,
Newly filed.
newly filed.
Yes. Yes.
I mentioned this, madam, and this is a contempt of Honorable Justice I.P. Mukherjee sitting with Justice Shubhendu Samanto. Their lordships deliver a judgment. That judgment has been flouted. That's why contempt application has been filed.
Contempt has been assigned to us.
No, contempt was assigned when my Lord Justice Samanto was in Calcutta. Then a bench was constituted, presided by my Lord Justice Aniruddha Ray and Justice Samanto.
Very good.
Then, after protracted hearing of the matter, last month, my Lord Justice Samanto has transferred from this High Court.
Order was not passed.
Everything was complete. Only thing matter to be disposed of. Otherwise, the one person has been already retired.
Chatterjee, it has to go before a bench comprising of justice.
I have already written to the Honorable Chief Justice for assignment.
Yes.
There, the comment was matter to be mentioned before the regular bench. What can I do? Because both the honorable judges are transferred from this.
When it is placed before the Chief Justice, the file has to be signed. That way it cannot happen. We cannot directly take up Mr. Chatterjee.
No.
mentioned before his Justice Boshak, his lordship is having the determination.
ওই অ্যাসাইনমেন্ট
That the determination.
যেগুলো আছে ওইখানে
Assigned the regular bench will be of Justice Boshak. So it
no
will-
no 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 this is a contempt arising out of education matter
maybe, but contempt jurisdiction is with Justice Boshak.
Where judges are not available. Where judges are not available.
Why? He has returned today itself.
No. The order passed by the initial judges are not available.
Right,
That
sir.
determination has been
mentioned
given.
before
ও
Justice.
আচ্ছা বসাক
Yes, what you have
Malad, one group 2 new application for inclusion in the list.
means new application.
Yes, Malad. It's an old matter, but it was never hard matter.
So what is the urgency suddenly
For
today?
application in the list, Malad.
Give a copy, notice to your other side. And
But I-
mention. Give a notice to your other side.
Regarding item number 70 of the monthly list, upon notice I mentioned the matter. This is application, but it is coming another heading here.
To remind us, we will call the list.
All right.
Yes,
Your Lordship, it's an application, Your Lordship, Section 5 application, new application, Your Lordship. The petitioner is retiring in 3 months. Her service benefits of
when
19,
did you file?
recently, 2025 itself.
Fresh application.
Fresh application, Section 5
Here.
application.
Yes, call the list.
My lord, may I be permitted to mention one matter, my lord? It is the matter WPA 6688 of 2000.
What you are wanting?
My lord, Dipankar Dasgupta's matter is listed on 5th December 2022, my lord. Our matter has been, it is an appeal, it has been assigned to your lordship's bench, my lord. My lord, I am praying. before
Which
your
matter
lordship-
assigned?
My lord, MAT 887 of 2025.
Yes, then what do you want?
My lord, I want it to be listed on 5th
Why?
December 2025 with MAT with WPA 6688 of 2022.
Why?
Because-
How it will be analogous?
Because my lord, we are on the similar.
You are mentioning upon notice.
My lord,
Are you mentioning upon notice?
sir, I have not served.
Then why you are mentioning? Please know the system of this
Sir,
court.
I'll serve and I'll come back.
Mention and come. Yes, call the matter.
Four I appear with the petition.
প্রথমে একটা ফার্স্ট কল দাও, ফার্স্ট কল দিকে যাও। ও অনেক আছে।
সুশান্ত, তুমি আছো?
প্রথমে দিয়ে আশিটা।
অন্যগুলো হবে না?
পরেরটা আসবে না। একটা ফার্স্ট কল দিয়ে
Five,
you're there.
for them, but
All right.
yeah, well,
Let
this
us
is the,
give a first call.
well, this is the hearing matter. Your lordships can post it January month.
Let us go through the matters first.
Hey.
একটু দেখে দাও।
Seven I also appear.
Item number 11, 12, 13, 14, 15. Item number 16, 17, 18.
18, I am for the appellant.
Yes, just wait. Yes,
15, 20, 21, 22, 22, 31,
30.
32, 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50, 51, 52, 53, 54, 55,
For appellant.
Yes.
56, 57, 58, 59, 60, 61, 63, 64, 65, 67, 8, 69, 70,
And for the petitioner appellant, this matter application, it will come under the heading application. Only section 5 was allowed. And I have some notice, Meenal Kanti Ghosh is appearing for justice.
76 টাকে
70, item 7.
70
70. This is my lord, Koshanto Kanti Ghosh.
থেকে
This is in respect of higher scale, physical education,
who is your other side?
Meenal Kanti Ghosh. I have served notice, upon notice I mentioned your lordship. So let it come under the heading application.
অ্যাপ্লিকেশনটা খুঁজে বার করে
অ্যাপ্লিকেশন লিস্ট করে দিও তাহলে
Much of it.
71,
Yet,
72, 73, 74, 75, 78, 77, 78, 79, 80. Item number 4,
তোমরা
এটা লাগবে কি ওই যে রেকগনিশন মেমোটা পেজ মার্ক করেনি তো পেজ মার্ক করেনি তো
yes which order is under
Meralda, I tell you, Lordships, don't open the brief. But it is in respect of the organizing staffs claiming for the teachers for the their approval. Now, Malay, it appears the school authority finally they have given the report that he is not working in the said schools. Now, your Lordship directed to sub the copy upon the school authority so that they can appear. Malay, if it is a fact that he is not working in the schools, then Malay, your Lordship need not open the brief. But the presence of the school authorities required.
And I've got the report from the school DIF in the
Mr. Buddy, you have served the paper books upon them 5
The school
and 6.
authority.
That was the last direction.
Yes.
This is the report.
This is the report of the school.
No, the report confirmed by the DI from the school authority.
Oh, I see.
DI has submitted us.
Yes, they have communicated, Mr. Buddy. 30th of April 20. Which is the order impugned?
Page, my lord, the page, page
59.
page 59.
Page 51.
Practically, page 69 is the impugned order.
Page 6.
69,
59 কেন
69 in the paper book.
ও সে দুটোতেই একই আছে
হ্যাঁ
দুটোই একই আছে
No, this report was called for by the
But
court.
earlier division bench,
Earlier division bench had the matter.
Justice Sen. Justice Sen and Justice Vitale.
What did their lordships say?
When nobody appeared for the state, that Justice Sen requested me, directed me to appear in the matter and to have instructions for the government.
I see.
That is on 21st April 2025.
That order was on 27 September.
No, 21st April 2025.
21st April. There is no 21st April order.
We also got it.
21st April.
The 21st. And then,
No, in the appeal, did justice send directive to file a report
no, directed to appear in the matter and to have
to take instruction? Oh, I see. So now you have come up with this report of the DI,
DI,
by which he has placed the report of the school authority.
school authority.
Then later,
Attended registered, etc.
this copy, a copy has to be given to him. বলেছে কি?
Okay.
দাও না একবার কপি দিয়ে দাও স্কুলে প্রেজেন্টেশন হলে হবে নাকি মানে we have served the copy of the paper book upon the school authorities, served the notice upon the school authority. Their presence is required.
But there is no affidavit of service. We directed it on 1st September, Mr. Badi.
Yes, yes, my lord, I undertake to file a review service in course of the day. In absence of the school authority, my lord, I cannot. I cannot place that. If it is a fact, he is not attending or he did not serve the school, then it's difficult for the court and difficult on my part to address him.
You join in which group, according to you?
My lord,
English.
No interview, no selection committee, nothing.
appointment letter is page 35. না না ইন্টারভিউ কি করতে
এটা তো কপি তো inspector service no one appeals for so I was
The school was recognized, upgraded. এটা টাইপ করতে হতো বোঝা যাচ্ছে না
Item number 5.
Till least it will be possible, or we keep it in February.
December, January.
ফেব্রুয়ারিতে করে দাও।
February.
Yes. Next.
Item number 5.
5 and 6, my lord, these are the identical matter. I do not know whether they are at all interested. You'll also keep in next monthly list so that I can take instruction. If it is infractuous, I can make submissions. Wow.
On the prayer of Mr. Badi, learned advocate appearing for the appellant. Five, six.
Item number 7.
I beg to appear on behalf of the appellant.
কিছুই ফাইল করো
না না এইটাই রয়েছে এইটাই রয়েছে তো
Paper book is there, Mr.
No.
not filed in spite of repeated direction.
I think the stay application, all the documents, I think
There is a direction for paper.
Yes.
yes.
Then Mr. Mukherjee, you have to file.
কত কত বছর অনেকবার অনেকবার পেপার কপি
হ্যাঁ,
বহুবার হয়েছে
না 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 এইটা লাস্ট হবে
এই দিয়েছি।
কোথায় গেল পেপার বুক কোথায় গেল
এই যে। কোনো তো কি, এই যে।
লিস্ট নয় নাকি এটা
বুঝতে পারছি না আমাকে এইটা তো তুই সার্ভিস করছিস এটা ইন্টারভিউ
ওটাকে আছে
প্রতিযোগিতা মার্ক ছিলেন ওই জন্য চেঞ্জ করে পুরো নেই।
কিছুই তো পাল
Kindly see how many times that court extend the time for filing the paper. Hey, with the David service check in courts of the day.
You are getting salary?
Yes.
Salary পাচ্ছেন। স্যালারিটা আমি
Arrear has not been paid, but the current is being paid. ওই দুটো এখানে রাখা আছে তুষার তুষার এই যে তুষার সুশেন
You will file. Mr. Mukherjee learned that additional government figure.
Eight, who is in eight?
লিখেছেন তো
Eight.
পেরিমিটারি করেছো তো? ইয়েস। হুম, 7 হলো তো এটা। 8টা ডাকো।
Matter number 8 with 9.
I'm for the appellant in 9 and item number 8 for the respondent state. But two appeals, one by the university, one by the state.
Then you are for whom? State?
State in the item number 9.
Yes, yes.
That is the appeal by the
Then
state.
you are respondent. Who is the petitioner?
Just give him. Just give him.
Paper book filed.
Paper file.
Then who is appearing for the?
Or initially, at the final hearing, Mr. Shaktinath Mukherjee appeared for the writ petitioner before the learned single judge. And Mr. Amitabh Chaudhary appeared for the university. Okay.
Mr. Joyanta Kumar Mitra is leading us, my lord.
Note টা কোথায় চলে গেল? মুশকিল তো। নোটটা কোথায় চলে গেল?
Yes.
Actually, Mr. Joyanta Kumar Mitra is leading us in this matter.
You will not never do the
Sir,
matter.
kindly please tell about date.
Never do the matter. All hearing matter, every list it is being called on and you will not do the matter. Amitabh Chaudhary appeared.
No,
Where
but
is he?
Joyanta Kumar Mitra also appeared.
So he is at his home and say, go and pray for time for Jayanta Mitra.
No, not that one. This is about date, my lord. We will try this.
How many times will fix up, sir? This is running in the last reach for 3 months. 3 months these matters are running. You are not interested.
No, not that one.
কি বলবে বলতে যে monthly list February করে।
Absorption of the PTA.
My lord, I am for the respondent board.
Hearing dismiss করে। জুলাই মাসে হয়েছে। ওর থেকে
And appears on behalf of the applicant.
I beg to appear on behalf of the respondent number 50. Yes. Yes, sir. 50.
Item number 15, 11 to 15.
Yes.
Item number 12 में सुष्मिता यादव तो ही
You are for whom? You are for whom?
Item number 50.
For whom?
Petition. Appellate.
Yes.
জি ওইদিকে যাও ওইদিকে যাও চিন্ময় দলিল
Yes.
No, I am for the appeal in this matter.
Any applications are pending in your appeal?
No application is pending.
No.
Can one is what? Stay application.
Yes.
Okay. $78 is the imprint order.
What are the other writ petitions about?
Issue is the same. 25th August 2017 notification is under challenge in all these writ petitions.
25th?
August 2017.
Where is that?
And this in my paper book, can you see page 45.
Are individually challenging it be dismissed. What did you challenge, Mr.
The notification dated 25th August 2007 is under challenge.
Page?
Page 45. Well, I am reading this notification. Can you see the preamble of the notification?
No, just a moment. This notification was challenged in the writ. Writ court dismissed your writ petition. So against that you have come up in appeal. Give us 2 minutes time to go through the order.
স্বপনদা ওর ক্লার্ককে বলেছি এবং আমি হোয়াটসঅ্যাপ করে দিয়েছি স্বপনদাকে আমার ডিউটি আমি
Yes, tell us.
No, damn. First of all, kindly see the notification dated 25th August 2017. I am reading this notification. In exercise of the power conferred by Section 20 read with Section 19 of the West Bengal University and College Administration and Regulation Act 2017, the governor, after considering the long pending process of recruitment of non-teaching employees in the government-aided college and also considering the needs of restructuring and enriching the West Bengal College Service Commission for carrying out the huge responsibility of conducting recruitment procedure for appointment of non-teaching employee in all government-aided college in West Bengal and also giving due regard to the needs of framing new regulation by the West Bengal Service Commission in this regard and in the matter of public service is hereby pleased to relax the requirement of provision subsection 1 of 10 of the Act, section 10, for the timing and until further order. This is my lord. Next, my lord, this is the preamble of the notification by virtue of section 20 and 19 of the Act. The power has been relaxed so far the section 10 is concerned. Now kindly see the next page. Next page.
Yes.
What is the ambiguity of the notification? 5, para 5. For all non-teaching posts, including promotional posts, except Group D post, knowledge in computer application will be desirable qualification, and the candidates having knowledge in computer application shall have preference against other. Therefore, except Group D, kindly note that. Except Group D, computer knowledge is desirable.
But this is a circular for fresh appointment, not for promotion.
No, this
Why
is
promotion has been added, including promotional post?
all non-teaching posts, including promotional, all non-teaching, including promotion. Therefore, and except Group D, the computer knowledge is desirable. Now, kindly see the para 6, Roman 2. Candidate engaged. This is Group D post. This is Group D post. Candidates engaged in on contractual or temporary mode of in the concerned college for a period of more than 2 years shall get additional 5 marks for work experience in the interview as compared to the other candidates, provided that the candidate is within the prescribed age limit. Therefore, the candidates who will be working in their college, they will be given 5 marks. And the candidates who will be working in other college, they will be deprived to get the 5 marks. This is the backdoor selection.
No, no, in the concerned college it is said.
It's in the concerned college. Therefore, the candidates who will be working in the concerned college,
So
they,
where do you get that? Candidates only working in that
candidates engaged on contractual or temporary mode in the concerned college.
college? Yes, this is a notification in providing the recruitment provisions of non-teaching employees in all government agencies.
My lord.
So concerned college will mean the college in which the person applying may have worked.
That's why the candidate who will be working in the college for 2 years,
Yes,
they
be
will
getting-
get 5 marks. But the candidates will be appearing but not working in that college, they will deprive of 5 marks.
Yes, at the cost of the service rendered for 2 years.
But this is
This is for the cost.
but this is not the transparency or accountability. Because the candidates will, because this will be a fair selection, because the candidates who will be not working in the said college, they will divert from 5 marks. This is not the intention for a fresh recruitment. Now kindly see next 2. The candidates having knowledge in computer operation in MS Office will also get additional 5 marks as compared to other candidates. Now in para 5 you are saying in case of Group D, knowledge of computer is not desirable. Now in para 6, Roman 3, you are saying so far the Group D is concerned, 5 marks will be allotted.
Where is the chart of allotment? For this examination, the written test will be 150. Now, where is the written test for Group D? No written test.
No, that is a walking interview. Kindly see 6, Roman 1. Interview for 3 marks.
In interview, 30 marks was allotted.
Yes.
That 5 marks and 5 marks is within 30.
Within 30. Therefore, my lord, para 5 says, except Group D, computer knowledge is reliable. Now, para 6 says, no, in case of Group D, so far the computer knowledge is concerned, 5 marks will be allotted. Similarly, my lord, kindly see, so far the Group C is concerned.
You are for which post?
I am for the Group D post.
Very good.
I am
not applied for the post.
1 minute.
He has not applied for the post.
No, that was decided. In the interim order, that was decided by the division bench.
So.
Well,
Yes, pursue. Proceed.
Well, Now, so far the group C post is concerned, kindly see Roman 4. Similarly, candidates engaged on contractual temporary mode in the concerned college for a period more than 2 years shall get additional 5 marks for work experience. Now, this is my
Then when was the advertisement?
advertisement.
Page?
I'm giving that. Page 38.
So this selection is not done by West Bengal College Service Commission.
No, this is that's why I'm making that submission. That's why I'm making that submission because by virtue of the issuing this notification, entire
Page 38 is of Dinhata College.
Dinhata.
There are many colleges all over West Bengal.
Yes.
You are concerned with this advertisement.
There are so far the 4 or 5 applications concerned, there are different college.
I see. Yes.
But issue is the notification.
Mhm.
Now, my lord,
Not appearing for all in all the appeals.
yes.
Item 12.
No, no.
For the appellant, my lord.
Item 12 you are for the who is in 13 and 14?
13, 14, my lord, I am for the appeal.
You are for the appeal. You are 50. Very good.
Now, my lord, the first, my lord, secondly, my lord, this notification was issued by virtue of section 19 and 12.
On page 38, the advertisement, please place.
The application are invited in a prescribed format from India citizen for the following post, group D post or substantive basis at Dinhata College. A laboratory attendant botany, laboratory attendant zoology, laboratory attendant geography, laboratory attendant physics, laboratory attendant chemistry.
Very
That is-
good. Then what happened?
No, where is group D?
The
Following group D post. Second line.
now this notification was
Second line and first word.
kindly see your lordship, kindly see this act.
So were you working in Dinhata College?
No.
You wanted to apply in Dinhata
No, I did not make any application.
for participation in the
I did not
selection.
make it
Then
because
who
if
are you?
before I am the aspiring candidate, I have got the requisite qualification. I did not make this application because entire notification is under challenge. If I participate, I cannot turn to challenge this
So
notification.
what is your present age? How much you are aged now?
My present is now 37, 38.
So what is your prayer? What is your ultimate prayer in the
Prayer, my lord, the
shut down the
The
notification and the
notification should be
advertisement?
declared. The notification should be declared as void.
Very good. Now any selection has been made on the strength of
No,
this?
by virtue of the order, interim order, in so many writ petitions, about 30 writ petitions, there is an interim order on the basis of a division bench order that you initiate the selection process but don't give this appointment.
Then what is the present status?
This is, my lord, selection process. In some college, selection process has been started. In some college, selection process has not been started.
No. In the 4 appeals, you are hailing from in the remaining appeals, it is from some other college.
Yes.
I see. So what is the status of those colleges? Group D post has been filled up.
No. Not yet filled up.
Have you made the colleges parties to this proceeding? Huh?
College party. College party.
So now if somebody has been appointed and he has worked for this 9 years,
Has
what
not been appointed as GA.
that is your contention. We have
No,
to
there is a
ascertain.
stay order. There is a stay order in all these matter.
What stay order?
Because division bench passed an order, kindly see the order of the division bench passed.
What is your instruction, Mr. Mukherjee? Any
But
post has been
some
filled up?
some college selection process over, some college selection process part because of the interim order could not give any approval.
So, where from we will get a status report to that effect? Because today, if some appointments have been made, then their right will be cut.
Then the director of public instructions, they are on subject to the approval of the director of public instructions is necessary before giving the appointment. We can call for a report from the director of public instructions respect of this notification.
No, we are wanting to know, as he says that there are 4 colleges. In this, he has challenged the notification that is applicable to all over state of West Bengal.
Yes.
But he has applied or not applied, locus standi was determined that he can challenge.
Yes.
Now the issue is, has there been any appointment in any of the colleges all over the state? Because if we struck down that notification, then all the appointments which have been given and not covered by the interim order also goes.
That I shall have to ascertain from the government. না কিছু কলেজ আছে কিছু নেই না কিছু কলেজ আছে
চ্যালেঞ্জ হচ্ছে অ্যাডভার্টাইজমেন্ট এন্ড নোটিফিকেশন, সেটার বেসিসে উনি বলছেন যে এই 4টে কলেজের ভিতরে দেয়ার ওয়াজ এন ইন্টারিম অর্ডার, কেউ অ্যাপয়েন্ট হবে, কিন্তু নোটিফিকেশনটা চলে গেল তো ইট উইল এফেক্ট অল দি পারসনস হু হ্যাভ বিন না ইমিডিয়েটলি এটা পারমিট অল ডকুমেন্টস শ্যাল নট বি ডিসপ্লেড। যদি আমরা ভেরিফিকেশনটাকে ব্যাড বলে বলবো
সেটা কিছু জিনিস ডিপার্টমেন্ট বলবো
ওয়েস্ট বেঙ্গলের নিচে 4টে কিছু আমরা জানি না। এটা তো তাদের আমার দিকে
West Bengal College Service Commission Bill 2012. You give the 17 Act. West Bengal.
Can you see first of all,
University and college.
2012 Act? I have given to 2012 Act.
No. This notification was public.
I understand. Initially Act has come in 2012. Thereafter 2017, this amendment has been done.
No. Can you see the 2017 Act?
It is what it is bill. Even if it is accepted that all the provision was enacted, then it would be West Bengal College Service Commission Act 2012.
Or is West Bengal College Service?
It is a bill. You have given a bill.
No, I have given
May I
the,
tell your lordship?
First a bill before
no,
the,
I have given the Act also.
for the legislature, and if all the provision is accepted, then there should be an act. But where is that act?
2017 Act?
Yes.
Kindly see.
Yes.
এইটা দুটো দাও, এই নাও, এই নাও।
Chapter 2, appointment of teachers, librarians, non-teaching employees.
Kindly see, my lord, chapter 3, section 10.
19 and 20. Shall be by commission.
Section 10. Notwithstanding anything contained in any order, in any other law for the time being in force, or in any customs or usage, to the contrary, an appointment of all teachers, librarian, and other employees of every college, except the college run by minorities, shall be made by the governing body on the recommendation of this commission, service commission.
It is
Now, my lord, this is the,
Now in relaxation of this provision, it's.
yes. Now can you see the power which has been exercised
then the governing body will be, will
Yes. Now,
initiate the selection process.
now kindly see section 19 and 20. This is very important.
20 has given this power of relaxation.
No, power of relaxation is restricted, not in general. Section 19, kindly see. I am reading that. Section 19.
Yes.
The state government shall have the power to remove any difficulty as may arise in applying the provisions of the Act to any college, not in college general, to any college. Now, section 20, kindly see. The state government shall have the power to relax any of the provisions of the Act or any rules, notification, order, scheme, or bylaw made under this Act, relation to any college. Therefore, the power is restricted. You cannot relax this power in general in all these colleges of the West Bengal. That power has not been given to you because by way of exercising this power, the entire object of the Act has been given go by. Then what is the utilization of enforcing this Act? Now, can you see section 21? There is overriding effect. Notwithstanding anything contained in any other law or in any custom or usage for the time being in force or in any statute or ordinance, rule or regulation made by any authority under any law for the time being in force, it is repugnant to the provisions of the Act. The provisions of the Act, to the extent of such repugnancy, shall have the overriding effect against any law, customs, and usage statute. Therefore, on my humble submission, when the that's why, my lord, 2017 bill, if I show to your lordship, before coming into that, the bill is clearly held for the transparency and for accountability. This is to be done by the commission. That's why, my lord, 2017 Act has been enforced by provoking this section 10. Only, my lord, for the transparency and for the accountability of the selection process. Now, my lord, by virtue of exercising this power, now the entire relaxation has been done in general to all these colleges in West Bengal. And that is totally, my lord, backdoor selection. And accordingly, my lord, this notification has been issued. Now, the candidate who will be working in that college will get 5 marks. But the other candidate will be deprived. 5 marks will be awarded to the group D staff having the computer knowledge, but the group computer is not desirable.
Then what is the actual selection criteria for group D post?
That has been given in the notification.
Where?
I'm giving that, madam.
Your argument is section 10, if applicable, no appointment can be made without recommendation of the commission. First point. Second point is that you cannot relax the power under section 10 as per your desire in respect of your suitable colleges. That is your argument.
And secondly, my lord, the power.
Please show us that what is the selection criteria of a group D, where it is provided.
My lord, giving that. My lord, can I see the page 45?
In the notification of August 2017, only 30 marks interview, 5 marks is additional marks. I don't know whether this additional marks of 5 and computer of 5 is included within 30 or not. So please show us what is the prescribed selection table. Like academics this much, written examination this much.
Commission Act.
Now, can you see para 3 of this notification? Page 45.
Yes. For conducting a selection process, selection committee will be. How they will mark?
Mark, that has not been given. Only 30 marks.
So are we to assume that the clause 2 and 3, 5 and 5 marks is included
within 30.
30 marks?
Within 30.
In group D post,
Well, how do you?
Then you tell us, Mr. Mukherjee, what is the selection criteria?
Kindly see clause 3 of the notification dated 25th August 2017.
Yes.
The college authority shall constitute a selection committee for conducting a selection process, and the selection committee shall comprise of the nominee of the state government a nominee of the university, a nominee of the governing body, administrator, as the case may be, and selection committee constituted for this purpose shall remain valid for a period of 1 year or continuous of selection, whichever is earlier. Next. Then the governing body shall advertise the post in a, intended to fill up in at least 2 days, having circulation in the district concerned in which the college is situated, one in English available and the other in Bengali, also displayed in the notice board website. Notice board. For all non-teaching posts, including promotional posts except Group D post, knowledge in computer application will be desirable qualification, and the candidates having knowledge in computer application shall be preference against others. For selection in non-teaching post, every college authority shall conduct selection process in the following manner. For a Group D post, through work interview 30 hours, candidate engaged on contractual or temporary mode in the concerned college for a period of more than 2 years shall get additional to 5 marks for or work experience in the interview compared to other candidates provided the candidate is within the prescribed age limit. The candidates having knowledge in computer
No,
operation.
but will be fine that this 10 marks is included within 30 marks.
Total marks is 30.
Yeah, have you?
Then that is your contention. That will include
Interview is 30.
interview will include 5 marks for
For experience. Experience.
And
Candidate,
teaching experience, but in the concerned college.
No, concert college, but if somebody college,
that
no,
means
concert college meant, but
a college which is initiating a selection process.
But somebody is working in a X college.
X college.
There is no advertisement, but another college is advertisement.
Y college.
Y college.
Y college.
But that means experience should be counted.
No.
But can't you see the language?
Use of the word concerned means the college which initiated the process.
Candidates having knowledge, but can't see?
That means he will not give any value to
Pay
the
temporary college
experience.
in the concerned college.
Concerned college means?
But according to my understanding, the concerned college means if some X college is advertised the post, there is has not advertised the post, but Y college advertised the post. He is working in a X college. His 2 years experience should be counted at the time of interview, provided he has computer training. That will be decided by the interview board, not by us.
So in a college,
In a college recognized by the government.
Or in any college?
Any college recognized by the government.
Okay, let us read again. Have you brought the rule? Commission, West Bengal College Service Commission rule? Prescribed by rule.
How the recommendation is issued by the commission in respect of Group D?
No.
How is there?
May I permit to give you 1 minute?
Yes.
2012, West Bengal College Service Commission Act 2012 came into force. Chapter 4 provides for non-teaching staff, including librarian, to be appointed by the College Service Commission.
Yes.
College Service Commission, that part of chapter has not been given effect to 2012 Act. That no notification has been issued under 2012 Act.
Any rule was framed?
No rule has been framed. That's why the government 2012 Act has been enacted by the parliament legislature, and section 19 and 20 has been giving the power of the state government.
Section 14. If it is
Section 14. 14.2 of the 2012 Act.
12 Act.
But that has not been given effect to.
Bill.
No, Kali,
Why you are giving us bill? Should give us the act.
But that chapter has not been given effect to by the government.
Yes.
Only lecturers and professors are recommended by the College Service Commission.
Kindly see the preamble of the Act. 2012 Act.
14.
14.2.
By the rule.
14.2. Eligibility criteria.
The 2012 Act, the Act shall come into force at once, except Chapter 4.
Then
Except Chapter 4. Now, preamble of the Act. These acts shall come into force at once, except provision of Chapter 4. Now, Chapter 4, can you see, deals with
selection of Group D.
of Group D,
of
not
non-teaching
teaching,
staff,
non-teaching.
non-teaching staff.
Non-teaching. Now, my lord, that's why 2017 bill has come into effect to that extent that colleges are facing difficulty due to non-recommendation by the commission. That's why bill has come into effect. That's why 2017 Act, Section 10 has been incorporated. All this appointment will be done by the recommendation of the Service Commission. Section 10 of the 2017 Act. Kindly see.
By the governing body on the recommendation of the Service Commission.
Yes. The governing body has the power only to make this appointment on the basis of the recommendation by the Service
And
Commission.
this notification relaxed
That-
that provision.
That Section 10 has been relaxed by virtue of issuing that notification on 25th August 2017. An entire object of the Act has been given go by virtue of issuing that notification.
Relaxed to the extent that the governing body will be the appointing authority and will initiate the selection process.
Therefore, there is no
Commission will not do.
question of any recommendation by the Commission.
But they prescribe the eligibility criteria.
Can you see Section
That
20?
notification prescribe eligibility criteria
But a
for the
section,
first time.
but can you see Section 19 and 20? The state government shall have the power to relax any provisions of this act or rule, notification or schemes, bylaws and act in relation to any college or
any
university in the
college.
interest of the public service.
This is very important to any college.
Any college means only particular college. College means recognized by the government.
To any college means not in general. All these colleges will be given relaxation. And
Why
this,
not? Why not, Mr. Dotto?
my lord,
Why not? State government shall have the power to remove any difficulty as may arise in applying the provisions of this code to any college
Yes.
or university
Yeah.
covered by the Act. So in all universities and colleges,
my lord,
this can be
kindly see
relaxed.
that. Any college means not in general, all these colleges.
That
Because
is
the
your
Supreme Court,
contention.
because the Supreme Court
No, no,
has,
you are trying to make out an argument that any college means special favor is being given to one particular college.
no. Suppose some college is facing difficulty in applying this provision of this act. Then the government has got the power to remove the difficulties by relaxation. But that doesn't mean all these colleges in West Bengal are facing difficulty. That's why the contention of this notification is that. And secondly, my lord, the Supreme Court has said that you cannot relax in general to go by the constitution of the act. That's why the act has been framed.
Which Supreme Court has?
My lord, on
What-
this,
what?
may I make a submission, my lord?
Just a moment, let us.
Hello?
What Supreme Court has said in any of the order passed in this proceeding?
I couldn't follow.
You're saying Supreme Court has said which judgment you
But
are.
I am giving that. I have brought this judgment. I have brought this judgment.
এখানটা ইয়ে আছে এক্সেপ্ট জায়গাটা এক্সেপ্ট আবার পার্লামেন্ট দিচ্ছে আর এইখানে যে কনসার্ন কলেজ অর্থাৎ সেই কলেজের কাজ করলে আমি কেন
যে কোনো কলেজে করতে
যে কোনো কলেজে সেটা কিন্তু করছে না। আমরা এই কনসার্নের মানেটা আনতে হবে ফ্রম দ্য প্রিভিয়াস
It is applicable to all over
কলেজ
West
অথরিটি শ্যাল কনস্টিটিউট
Hmm.
দ্যাট কলেজ দ্যাট মিনস কনসার্নটা আসবে এইখান থেকে মানেটা
This regulation is for all colleges. For conducting process by the college authority for recruitment. এই যে preamble for conducting the selection process of the college.
এই সময় তোকে যে বারোর একটা কপি আছে এক্সট্রা আমারটা কত স্পেস থাকবে
এখানে
বারোর একটা
একরকম মানে
কলেজ সার্ভিস কমিশন
পুরে একরকম মানে
ওটা কত স্পেস থাকবে তো তাহলে এক মিনিট যেতাম
কারোর এক নেই এত
না, ওটা ছিল, আমাকে তো মিসপ্লেসড হয়ে
হ্যাঁ,
গেছে।
সব জজসাবকে দিয়ে দিয়েছে।
আমারটা মিসপ্লেসড হয়ে গেছে।
যেখানেও চাকরি করছে।
In any concerned college, in any college, হলে ঠিক হয়ে যাবে।
হ্যাঁ, in any college কনফিউশনটা এই আর কি। In any college এইখানটা। আর এই যে জায়গাটা দিয়েছে, এই যে এক্সেপ্ট গ্রুপ ডি,
ওইটা ভুল,
এক্সেপ্ট
গ্রুপ
গ্রুপ
দিয়ে
ডি
এটা ঢোকাচ্ছে,
দিয়ে আবার
কন্ট্রাডিক্টরি।
দ্যাটস
ও কি রিলিফ পাবে? ওটা বেটি কনসিডারেশন। College, even if we even if we leave that point, what do you say about clause 5 and clause 6 too?
5 and 6, just use.
Clause 5 says except group D.
Kindly for all non-teaching posts, including promotional post except group D post, knowledge in computer set should be desirable qualification.
Right.
And the candidates having knowledge in computer application shall have the preference against others. But there is no difficulty. Now, for selection of non-teacher, FD college shall conduct the selection process in the following manner. For group D, through walk interview 30 marks, candidate engaged in a contract.
Clause 3.
Clause
Clause 3. Candidate having knowledge in computer operation in MS should also give additional 5 marks as compared
How
to
can you do this in view of clause 5?
Clause 5, that is
Computer story is excluded
no, it's a desirable qualification.
in respect of other posts, not group D, except group D.
Except group D, but group D,
Then it becomes contradictory, na?
No contradictory. If somebody worked in a college, if he has computer knowledge, nowadays everything.
That is your argument.
No.
Where is the rule? You could have said that except group D, you should not have included. When you include in 5 except group D, in all non-teaching posts, computer will be desirable. Then it is compatible to the clause as exists in 5.3.
If somebody applied for the post, what a number?
You cannot proceed on assumption. You
No.
state.
No. For filing a writ petition, he must be an agreed person.
That is separate.
Number
I am
one.
asking your
Interpretation. But kindly see for group D
No,
post,
we
what
have seen. You please apprise us that when in clause 5 you say that group D is excluded. So group D will not be in any manner linked with computer duties. Computer qualification desirable, non-desirable, not required for group D. After you say it is not required for group D, how can you give 5 marks to those who are having
no,
desirable?
if somebody, it is not essential qualification, but if somebody has got qualification,
Essential, you're right, it is not an essential, it is a
desirable qualification.
so for group D it is neither essential nor desirable, then why you are giving 5
No,
marks?
no, when you see a policy decision of the government to improve the,
Mr. Mukherjee, you are going on other right. Policy decision cannot interfere, we understand. But policy decision has to be non-arbitrary.
yes,
Or
but
it
is
can,
it arbitrary?
because of this reason, you are saying appropriate and if you first say that group D in respect of group D computer qualification is neither compulsory nor desirable,
Desirable.
it is totally out.
Oh.
So group D you have to consider only without giving any weightage to any person who has computer pertaining to group D.
But this, my lord is troubling with clause 3.
Clause 3 and my brother is troubled with clause 2.
Clause 2, let us see. Candidate engaged on contractual or temporary mode in the concerned college for a period of more than 2
So
years.
my brother's interpretation is in this concerned college will mean the concerned college in which the selection is being held, because such selection is being considered by a selection committee especially constituted for that said college. That is clause.
Assuming for a moment your Mala Justice Chatterjee is correct. Absolutely that. But if somebody works, because there are large.
Give us a clarification that this has not been restricted to any particular college. In all colleges, it is available. Very good. We will actually record your submission. In clause 6(2), what are you candidate engaged on contractual or temporary mode in the concerned college? You could have said in any college. All over West Bengal, suppose there are 500 colleges.
Yes.
If you have said any college, suppose I do not work in Dinhata, but I have a right to participate in this selection. So when I participate, you will give me 5 marks for experience. Suppose I have worked in another college.
Yes.
If you say any college, then all colleges come within the fold. But concerned college will go to the selection committee.
College, my lord Justice Chatterjee said concerned college who is conducting the selection.
Yes.
Yes.
Am I wrong?
Yes.
But in my understanding, concerned college, if somebody worked in a X college and there is no vacancy,
right?
Can't see, but there is no vacancy, no advertisement, then he will suffer. Statutes to be interpreted for the interest of the public at large. A college, somebody is working more than 5 years, no advertisement, no selection process. Then another college advertisement is made and giving 5 marks for experience. But he will suffer. That's why the.
Oh, Mr. Mukherjee, if the legislature used the word concern, the meaning of that word shall be found out from its preceding paragraph.
Yes.
Preceding paragraph.
Yes.
Concerned is like a pronoun, it has been used to qualify a college authority which has been previously referred to or referred to in the preceding paragraph. So you are giving by this notification, you are giving power to a governing body of a college to initiate a selection process to fill up the non-teaching staff. In relaxation of this power, generally commission has the power. In relaxation of this provision, you are giving this power to the governing body of this college.
Why?
Now you are saying that college authority, however, before initiating that proceeding, is to obtain prior approval from the state. College has to constitute a selection committee, and the college authority shall award marks for having teaching experience in the concerned college. Means
No, just, but why this has been, this notification has been issued? But kindly see page 45, why this notification has been issued by the government? First, but because 2012 back, chapter 4 has not been notified. That means,
I know, I most probably I couldn't properly communicated what I am want to say. The concern, the meaning of these words shall be traced from the preceding paragraph.
but kindly see the college authority.
That
Appointed by
means
Crosby.
the college
Page 45
authority
process.
referred to in the previous paragraph.
Kindly see page 45.
Let
Para
us
3.
understand now, one order was passed on 9th January 24. Do you have that order? 9th January 24. You have an order passed. Coordinate with the 3rd October. The present question. This appeal is against an interim order. Against an interim order.
No. This appeal against
against
the
the
final
dismissal.
order passed by Justice
Against the
Sinha.
dismissal.
But other appeal against the interim order.
Other appeals are against interim
Interim
order.
order.
That is refusal of interim order.
Yes.
No. উল্টো করে বলছো।
Go him to
My lord, only Manbhum College,
Item 15.
item 15, I got this order before the learned single judge.
which order? This order which is challenged.
But this writ petition,
Hmm.
so far the Manbhum College is concerned, I moved the writ petition, I got the stay order from the learned single judge. College preferred this appeal before your lordship.
Item 15.
Item
Item 15.
So where is that interim order? Passed in Manbhum.
Manbhum College.
You have to give us a chart now. How can we take a
Manbhum.
And
there is a Supreme Court order it refers to
Yes.
of
so Somajana.
Somajana.
And what
That is
happened
SLP
at your
number.
lordship?
not Somajana.
Somajana.
Order of the Supreme Court dated 8th December 23.
8 December
This order which you are
2023.
showing is of 19th of April 24. Where is that 8th December 23 order, Mr. Dotto?
Is December 2010.
You cannot record.
This is this is Somajana.
Which this is Somajana.
No.
That is in all the appeals. This order was passed on 9th of January 2024. 8 December. You will say? Is it pending? It is Somajana. ঠিক আছে।
It is pending before the Supreme Court.
No, this.
Mr. Dotto,
The same issue was, Mr. Datto arguing that point has been rejected by a division bench of our High Court in mat number 13 of 2019, and against which an SLP has been filed, SLP number 26657 of 2023. No stay has been granted, the notice has been issued
In the order of Justice Harish Tandon?
at Jalpaiguri.
No, Jalpai.
3rd October 2023.
3rd October 20.
In a Jalpaiguri bench.
Where is 3rd October 2023?
Mat number 13 of 29.
No, 3rd October 23 is in Somajana.
Somajana.
So Somajana went up.
In a Supreme Court.
Somajana has been disposed of now.
No, I am telling to lordship.
Somajana SLP has been filed by Somajana.
Somajana is pending.
No,
before the Supreme Court.
Somajana pending. To dispose of.
According to my information, Somajana is pending.
Oh.
Appeal is allowed. Judgment of High Court is set aside.
Yes.
3rd of October, appeal court order has been set aside by the
No,
Supreme Court.
division bench dismiss this appeal on the ground that you have got no local standard since you didn't appear before the interview.
Yes.
Against that order, SLP was preferred, SLP set aside this order, my lord.
Yes, so that
And
point.
the appeal is pending now. Because the appeal is remanded back.
That is what we are hearing.
Well,
That is in case of Somajana.
Homajana.
And in the other matters,
We have not expressed any
Mangu,
opinion on the merit of the.
you said in respect of Chinmay Dolui, what has happened?
This is your lordship. This is paper book.
This is against the order of Justice Orindam Sinha.
My lord. Dismissal.
First matter is Justice Orindam Sinha.
Somajana is of Justice Rajsekhar Man.
Rajsekhar Man.
Acha. And Mithurani,
Mithurani, my lord. This order I have given to your lordship. Kindly see this order. Division bench order. 10th January in 2019. I have given to your lordship.
unless you make a synopsis, how will we understand this? Tell us. এগুলোকে একটু স্টেপেল করে অর্ডার শিট গুলোকে সিরিয়ালি ডেট অনুযায়ী অ্যারেঞ্জ করে স্টেপেল করে না বের হয়ে যাবে।
10th January 2019.
কেন এত 10th January you have given? Mithun and Noyon Pramani.
Yes, Mithu Jana, Mithu Pramani, and non Pramani. Mithu Raj Das, non Pramani.
And college has preferred appeal against which order?
Hello?
College has preferred appeal against.
Item number 15.
50.
College has preferred an appeal against the order passed by the Amrita Sinha.
Honorable Justice
Amrita Sinha.
Orindam
18th
Sinha.
of June.
Amrita Sinha. When I moved the writ petition before my Lord Justice Amrita Sinha, where I got the stay order, against that they preferred this appeal before
I
the. And also the my lord, appeal was also they declined to give any order of stay. Stay application has not been, my lord. The division bench did not pass any order.
So, Mr. Dotto, unless you file a composite paper book, how will we proceed from so many documents?
No, only one thing, my lord, kindly see the division bench judgment I am giving to your lordships.
In
10th
which
January 2019. My kindly copy
30th?
THC.
10
10th
10th of
January.
January 29. Yes,
Yes. You also kindly, this matter was moved
this is Mithu and Nayon.
now. But kindly see page 8 of the internal page 8.
This is also in connection with interim order.
Injunction
No.
interim order.
No,
Amrita Justice Sinha passed an interim order against which college preferred an appeal.
this is appeal, Manmoham College.
Item
And
15.
so far this matter is concerned,
Mithu.
my writ petition was dismissed. I prefer this appeal.
On the locus standi ground,
Lucas Tandai and also passed an interim order.
preferred an appeal. Now appeal court, what it has said?
Man, kindly see page, internal page 8, last paragraph. So far the other points is concerned, the locus of the petitioner takes a back seat when the challenge is made to the rule-making power exercised by the state provided in the Parent Act. The apex court in case of Binod Kumar observed that unless a person discloses the circumstances which affects his right, he cannot approach the court. If a notification has excluded an aspiring candidate to apply for the post when the earlier clause excludes such stringent condition to apply to the post D, we do not feel that the petitioner is still not an aggrieved person and no right is created upon him to challenge the notification on the anvil of reasonableness. If a person is deprived of an offering his candidature for a recruitment of certainly it infringes the fundamental right guaranteed under the Constitution, and therefore we do not feel that the writ petition is not maintainable on such ground. Both the points touching upon the locus standi and the maintainability of the writ petition has no legal substance, and therefore we hold that the writ petition is maintainable. So the appeal dismissing the writ petition filed by the appellant. Again, the order to avoid any conflicting decision on the merits of the writ petition we feel that this appeal should be tagged with the other retribution which is heard in part by the other division bench. Accordingly, these appeals are released from our bench and be placed before acting Chief Justice for passing an appropriate order. Since we find that the points urged in the instant petition required to be considered, the petition cannot be left out without any protection. Accordingly, the respondents' authorities are restrained from giving any appointment to the group D post pursuant to the advertisement, which is impugned in the writ petition. However, it is open to the respondent authority to complete the post-election process in the meantime.
This is a by an interim matter, not final decision. And when I kindly see,
So now against this order, you went to Supreme Court.
No,
No.
this appeal is before your lordship.
So the writ petition is yet to be decided. Writ petition in Mithu and Noyon was dismissed on the ground of locus. So that has been struck down and said that the writ petition is maintainable. But the court is saying that this writ petition be placed before another appeal court, which is hearing similar writ petitions.
Now, my lord, your lordship, another appeal is pending and as a partner matter.
Before whom?
Before my lord Justice Dipong, as the also then the was,
Before
Justice Dipong Godot
Justice Dipankar.
Yes.
at that time. Now, my lord, when my lord, their lordship has observed this appeal is partner before this bench. The
And
same
Justice-
appeal here,
Justice
we are
Pati
releasing
Pukar
this
Banerjee.
appeal and tagged with that appeal.
This is in 2019. After that, Justice Dattor transferred to Bombay High Court and Justice Banerjee is no more there.
So
Now,
that has been assigned now. That
No.
is regular bench, it will come.
Yes.
regular bench. Now, no regular assignment is necessary.
So which is that matter? That matter has not been included here.
No, here no.
So that is also relating to this. You are the writ petitioner there. Haphazard হয়ে পড়ে গেছে। And that appeal was preferred by whom? Another similar,
By another aspiring candidate,
in whose case the interim order was refused.
refused.
Against that,
No. Writ petition was dismissed.
Oh,
Against that,
that-
appeal was prepared.
appeal was preferred.
Appeal court passed that order.
No, this is Justice Tandon's order,
My lord,
which was
Justice
parted
Dotto-
before Justice Dotto.
my lord,
That will also be guided by this order then.
automatic.
Because in that order also, locus point writ petition was dismissed. That appeal is pending. তাহলে তো
No. Justice Dattor refused to pass an interim order.
which has been passed by Justice Tandon.
There is a two
Tandon-
conflicting orders, that's a difficult.
So, Mr. Mukherjee, we will be passing an order which may affect all the appointments which have been made pursuant to this notification.
When a college are suffering, government is suffering.
We may, there are plenty of ways dealing with it. One is that we may, if we uphold his prayer, then the notification goes. So if the notification goes, then the person's appointment also goes. So we have to say that our declaration will not touch the persons who have been already appointed. So unless we get that status from you, that how many candidates in West Bengal have been appointed
Pursuant to the notification.
pursuant to this notification.
I should have to ascertain from the
You
department.
will file a statement.
ওদের ইয়েটা বলুক ওই যে apparently it is appearing that group D accept but there has been awarded marks for having qualification and the concern
Yes, in some cases,
can
selection process has already been over, but appointment could not be given. In some cases, selection process started, then interim order stayed.
এই যে প্রিন্সিপাল সেক্রেটারিকে what is the stand of the state যেটা ও argue করছে।
In any of these appeals, you have used any opposition?
No.
যদি ওদের ছেড়ে জেনেছিল তখন না? কত অ্যাপয়েন্টমেন্ট হয়ে গেছে এইটা আনতেও পারবে না।
আনতে গেলে 2 মাস 1 মাস টাইম
After publication of the notification, whether today you will fulfill the conditions in that notification, nobody knows,
The notification has to be issued afresh.
right? We
If
could
your
have- but
lordship-
by that time, see, 9 years have gone.
My lord,
In this process, 9 years have gone.
my lord.
Suppose a fresh notification is issued, we don't know what will be the age criteria. Suppose 5 marks for computer and 5 marks for working is deleted. Then also you will have to be tested for 20 marks by the said selection committee subject to your application if you appear in that selection process.
I understand. And so far, this is
Unless Mr.
Mr.
Mukherjee,
Mukherjee, you have a talk. There is apparently there is some conflict or confusion in the notification. You have used the word except group D. On the other hand, you are awarding marks for having knowledge in computer operation to the candidate who will submit their candidature for the group D post. It is contradictory.
In my respect, your lordship may be correct, but in my respectful submission, there is no division because 2012 Act is there. 2012 Act
Desirable, the word is very confusing.
Concern college.
Prescription
Concern college.
or qualification for any post is made essential qualification.
Yes, yes, yes. Or a
One
desirable post.
candidate must have such qualification, then only he will be able to offer his candidature for the post. Essential. Now, sometimes the word preference shall be given.
Yes.
There is a confusion, preference.
Just like B.Ed.
If
Preference shall be given to the B.Ed candidate.
you find that 2% secure two similar marks, same mark, then you can say, I shall give preference to that person who is having computer knowledge. But preference means whether you will award certain marks. Preference means it may be that 2% securing same marks, then I shall give preference the person having computer knowledge. It may be. Now, desirable means
It may be or may not be. May not have.
Indication that if you have, we desire that if you have computer knowledge, then only you apply.
No, what are desirable? If he does not have a
What is
computer
desirable?
experience, he can appear before the board, but he will not get
The
the mark.
selection committee desire that this person having such qualification only apply. What is desirable?
But in a selection process, not only one, 5 persons are there. For university nominee, college nominee, government nominee, governing body nominee. Not an individual person. If an individual was there,
You are giving number means you are curtailing the discretion of the body taking in the interview.
no, we are
Actually, found
not taking any
person
power.
having
If somebody
computer
has got,
fine.
if somebody has no qualification or experience in computer, he will not get marks. What's the difficulty?
ইন্টারপ্রিটেশন তো দিয়ে রেখেছে আমরা তো যে গল্পটা তো আবার বলবো
না না
এখন ওদেরকে এভিডেভিট কল করে ওরা এক্সপ্লেন করে also you are appearing. Do you have the particulars of that order?
at the present moment,
That which matter? Item appeal number.
I can remember just it was hard before Justice Dotto in court number 3. That's why before
That is same notification was challenged.
challenge.
সাবমিশনটা নোট করিস
Because the number
আর কত অ্যাসাইনমেন্ট হয়েছে সেইগুলো ডিসকাস করে তোমাকে
because the number থাকবে তো
চিন্ময় দোলাইটা
চিন্ময় দলুইটা মানে কাইন্ডলি যে চিন্ময় দলুই
this was
that number 714
at Chinmoy Doloi, this matter was quarter before Justice Dotto.
This matter.
This matter.
So there is no other matter. We
There is
can
no-
hear this.
There is no other matter.
Hmm. Then What is the reasoning given by the single judge in your judgment?
Well,
Page
page 45,
78.
sorry,
Page 75.
78.
75
How
relevant.
these 2 points were dealt with, Mr. Dotto?
My lord.
These 2 points, how the court dealt with?
No, my lord.
One was for reservation, you say,
Reservation.
impunity excludes group D.
Well, kindly see, it's page 78, last paragraph. Mr. Chakraborty submits that section 10, as you also got it.
Yes.
Section 10 of West Bengal University and College Administration Regulations Act 2017 cannot be relaxed in the purported manner as by impugn notification. Section 19 and 20 of the said act does not allow for providing new provision in saying that statutory provision has been relaxed. He then relies on the West Bengal Civil Code. I am skipping that. Next paragraph. Mr. Chakraborty submits further that though clause 5 impugn notification excludes from group D post candidates from having to possess the knowledge in computer application as desirable, but under clause 6(3), additional marks have been provided to be given to those having called knowledge in computer section. Clause 6(2) provides for additional mark to be given to candidates engaged on contractual or temporary mode in the concerned college for a period of more than 2 years, which is in conflict with memo dated 24 December 2018 of the Government of West Bengal Education Directorate, whereby there was a direction to abolish every post-public engagement which was not sanctioned by the government. Then Mr. Mukherjee, learned advocate, appears on behalf of the state and submits that section 19 and 20 of the West Bengal Act 2017 provides for relaxation as has been done in this case. Petitioner did not apply, but instead made representation followed by demand for justice and the writ petition. The writ petition has no merit and it should be dismissed. College is not represented by what court proceeds on satisfaction of service as aforesaid. Section 19 of the West Bengal Act 2017 is not applicable to the present case since the impugn notification says that the governor inter alia giving due regard to the needs of framing new regulation by the West Bengal College Service Commission in regard to what has been stated in the notification and in the interest of public service is hereby pleased to relax the requirement of provision subsection 1 of section 10 of the Act. The manner of relaxation has been given in the notification. Nothing has been demonstrated to show that there has been no relaxation in the manner provided by something else done. So for the contention regarding the reservation, I am not skipping, telling that, skipping that. Now these notified relaxation accepting group D post candidates from having desirable computer knowledge, here providing for additional marks is a procedure selecting the candidates, whereby the candidates for the group D post not having computer knowledge is eligible for work-in interview, but selection may be made of a candidate having computer knowledge. So also is the case of a candidate who had been employed on casual or temporary basis by the college for more than 2 years has been chosen as against it being eligibility criteria. For the reason aforesaid, the petitioner is found to be without merit.
Relaxation for having yet providing additional.
But that is not been clarified.
Instead of selecting candidates.
Procedure.
Was filed, any opposition was there for your
No. Paper was
judgment? Call করে নাও, ঠিক আছে শর্ট করে দিও তোমার পুরোটা না না নো প্রিভিয়াস already coded is
Item number 16.
16. Please, the advocate record, my lord.
I am with Mr. Das, Lordship.
This appeal is preferred, my lord, against the order dated 27th January 2021, passed by the learned trial judge. Whereas the learned trial judge has not been directed that
Your service is complete.
service complete.
Where
Even,
is
my
your
lord, recently,
evidence?
my lord, one Pinaki Bhattacharya and my lord, other persons, he junior, is appeared. And to file an opinion opposition since connection with the Can 1 of 2022, passed by lawsuits.
Affidavit in opposition.
My lord, 20th February 2024.
20th February.
20th February 2024. Mr. Bhattacharya, learned advocate appearing for the state respondents, prays for leave to file an affidavit in opposition to the said application being Can number 1 of 2022. That such affidavit in opposition be filed within 3 weeks from the date, reply thereto, if any, be filed within 2 weeks thereafter. The party will be at liberty to mention the matter. But till date, my lord, no affidavit in opposition
Has
not
been filed. Very good. You tell us then, place the matter.
My lord. Petitioner was an assistant teacher in my lord, St. Joseph High Schools at Barwan. The secretary of the managing committee issued a so-called notice dated 18 March 2008.
Where is the order? Page 63.
Well, that is page 63. Is the impugned order.
Just. You did not make any application for substitution?
Well, there is some defect in regard to this. The original writ petitioner, the Govinda Prasad Sinha, was the writ
This
petitioner.
Shashi Sinha.
Shashi Sinha is the wife.
So Robindra preferred a writ petition being agreed by an order of 25th November 2013.
13.
That was filed after 3 years.
In the year
So,
2018. And 2019, the writ petitioner died. That is 20th.
He retired in 2008. And he filed the writ petition?
No. Dismissal order passed on 13th June 2011.
13th June 2011.
Yes.
Where? We are not on that. You challenged an order of 25th November 2013.
13.
That is by the commissioner.
Yes.
You challenged that order. Challenged that order after 3 years.
After 3 years.
After 3 years. And when you preferred that order, preferred that writ petition, you have retired.
During this pendency of this writ petition, the writ petitioners died.
Read petition that you did not come up with an application for substitution?
No, but what happened in the meantime? The aforesaid read petition was, my lord, taken up for hearing by my lord Justice Gangopadhyay. Now,
Which
hearing,
read petition?
my lord, in the instant read petition earlier,
Yes.
that my lord, hearing was concluded, no CAB or no judgment was delivered. Now, during this, my lord, period,
The petitioner did.
the petitioner died.
Then you did
2000
make any application for substitution?
Because my lord, the Gangopadhyay has already been, my lord, judgment has been delivered that it has been abated. Read petition has been abated. My lord, I have got the, my lord, the order. Hearing concluded and judgment reserved on 18th December 2018.
Then
ultimately,
no judgment was delivered.
no judgment was delivered. But as an when before my lord, transfer or retired from this court, then my lord, the judgment has been appeared before this honorable court. It has been released without any, my lord, reason, any order,
Very
effective
good.
order.
Very good.
Now after that, my lord, nothing
What
was.
is that read petition? 29090?
My lord, that read petition is 29090 of 2017. And the same state
So
advocate.
that read petition is still pending.
The read petition is already been,
Then
my lord,
why this read
abated.
petition 17210? In that you did not get substituted. You came and filed a fresh read petition.
No, but it has been, Gangopadhyay has been order passed that it has been abated since.
Yes, abated, right.
Abated.
Now you filed a fresh read petition.
Fresh read petition.
How can you do so?
But that's why, my lord, I was advised to my junior that until or unless the substitution petition is not filed, then the appeal or any other applications has not yet been maintainable.
No, in this read petition, show us the 25th November. What was the challenge?
My lord, challenging this, my lord, the Director of School Education passed on 25th November 2013. There is in 3 increments has been punished. Although the petitioners, my lord, the husband of the petitioners was, my lord, allowed to get pension. Only 3 increments was not allowed. That is the punishable, little punishment. Having after removal of that appeal authority, being an appeal authority. Now, accordingly,
So a lesser penalty was deducted.
my lord, that is page, your lordship, my lord,
56.
page 55, 54, start from 54.
Yes, we have seen that. Challenging that order, you preferred the read petition.
Yes, this is the instant read petition, which was, my lord, under challenge in the appeal.
Dismissal of the school authority has dismissed you. It has to go to the board, no? How can the commissioner pass this order?
Well, kindly see my lord, the page 56 in the bottom. In view of the above, I am of the opinion that the dismissal of the petitioner, Sri Govinda Prasad Sinha, from his service just before his superannuation is not an appropriate action on the part of the school authority. A lesser penalty may be appropriate to serve the ends of justice. Therefore, in exercise of the power conferred on me by DO number 61 EDN dated 23rd May 1974, it is ordered that Sri Govinda Prasad Sinha shall be allowed all the service benefits, including retirement benefits, teaching him to be on service from the date of his suspension till the date of his retirement or superannuation. Number 2, last 3 annual increments will be
Now, how
deducted.
this read
the last
petition is
basic pay.
maintainable, Mr. Das?
Well,
This read petition, how maintainable? 25th November 2013 order was challenged 3 years after that.
that is, my lord, the
And judgment was reserved.
the
A person died. So you should have got yourself substituted in that matter.
no, this is a, my lord, separate read petition. This
How
is
you
not
can
the,
file?
my lord, the Govinda Prasad Sinha has been filed.
Huh?
Govinda Prasad Sinha, when he was alive, 19456 of 2012. And that was in 1970, 2017.
After the order of 25th November 23,
My lord, 2013.
2013,
My lord.
this Govindo Prasad Sinha preferred a writ petition.
Preferred a writ petition.
That in that writ petition was preferred 3 years after that.
My lord, that's true. But 2018, that was, my lord, the learned trial judge has been maintained that earlier writ petitions in 29090 W of 2017
Was delayed.
that was delayed. Now, in the meantime, my lord, the paragraph 4, in my view, this writ petition is not maintainable as there is an inordinate delay on behalf of the original claimant, the petitioner's husband, in filing the writ petition in the year 2017, challenging the order of 2013. So that's why the writ petition was disposed of. No order was.
That is why this writ petition was not entertained.
Not entertained.
Now, what was your prayer in this writ petition?
That writ petition is not. I think
Page
it has been
28.
annexed in this petition.
So how can you challenge the order of 25th November 2013?
স্কুল অথরিটি ওকে ডিসমিস করেছিল, তারপর ও সেটা গভর্নিং বডির কাছে অ্যাপিল করেছিল। গভর্নিং বডি ও ডিসমিসাল অর্ডারটা রেখে দেয়, তারপর ডাইরেক্টরের কাছে অ্যাপিল করেছিল। দ্যাট ওয়াজ পেন্ডিং। এবার চ্যালেঞ্জিং ইনঅ্যাকশন ইন ডিসপোজিং অফ দ্য সেড অ্যাপিল, হি ফাইলড দ্য আর্লিয়ার রিট পিটিশন। এই যে 19,456 সেটা ডিসপোজড অফ হলো 17/12/2012, directing the matter was taken up by the secretary আসছে।
না, ওটা কেন করছো এখন? তো ওইটা তো অ্যাবেটেড হয়ে গেছে।
হ্যাঁ, সেইটা হলে এবার কমিশনার এই অর্ডারটা দিল। এইবার এটা 13তে অর্ডার দিল, মানে হাজব্যান্ড চুপ করে বসে রইল।
3 years
17তে এসে ফাইল করলো, 17তে এসে সেটা নিয়ে অ্যাবেটেড হয়ে গেল। তারপর অ্যাবেট হওয়ার পর এইটা পাই 19-এ 2 বছর পর।
Having after abated, my lord, there is no scope for any substitution because there is no any pending. There is no any pending in the writ petition, whereas my lord Justice Gangopadhyay has already been, my lord, order passed that.
Where is Justice Gangopadhyay's order?
My lord,
এইটা নিয়ে আসুন, এই সিপিসিটা দিন। What is order 22 rule 9?
my lord.
When was it dismissed by, when it was judgment reserved, you are saying, where is that order?
Lordship, page 17.
3rd July 2019. Your lordship, my lord.
Page 7?
9090.
Debits is dismissed under this order. No case shall be brought on the same support. You can may apply for an order to set up a judgment. Why? Why should I show too much? Remedy ছিল setting aside of amendment to approach.
এটাই সেটেছে। You withdraw the appeal and go and take steps for setting aside abatement and for substitution.
Your lordship can kindly give a liberty, but there is some delay that will be condoned. Otherwise, well, at the 2017, if I proceeded before the learned trial judge,
Maintainable বলতে হবে, তোমরা শুনবে কি করে? ও তো ওই রিট পিটিশনের সম্পর্কে বলে দিয়েছে। Because that could not have been entertained as a review of the delay.
only in respect to all pensionary benefit is given. Only 7 except the 3 increments was stopped or not provided. But the pension has been given, there is the less amount of that notification. This is the main appeal of this prayer of this appeal. Only petitioners will suffer only for less amount because there is a pensionary benefit.
সেই মেরিটে ওই পিটিশনটাও ডিটারমাইন
ওইটাও কিন্তু ডিটারমাইন, ওটাও কিন্তু
তাহলে তোমাকে এটা মডিফাই করে দিতে হবে।
How much will be the money?
কিছুই থাকবে না।
And how you will cross that barrier? 2013, your husband challenged the said order in 2017. 4 years, no explanation. Thereafter, due to tendency of that petition, your husband died. One court says the matter was abated. If any matter is abated due to death of any litigant, then only remedy is by filing an application for setting aside the abatement. Fresh proceedings cannot be initiated. Otherwise, abatement will, there shall be no importance to abatement.
But
It
now,
will be abate,
then
then fresh.
if your lordships will given liberty to the appellant to make an application for setting aside the
Now, without taking any steps to set aside the abatement, you file a fresh petition.
yeah that is a wrong view. That is the wrong advice. Wrong advice.
That after 2 years.
Yes.
I mean, actually,
even in absence of the
actually in 2019, you are challenging the order of 2013.
13. Yes, that's right. Only for procedural defect. Only procedural defect.
Incremental benefit is given, how much you will get?
But only for fixation of pay.
There is some
Fixation of pay is the less amount of the pension. Because fixation of pay is wrongly it has been calculated by the authority. So if it is not the
okay, yeah. Suppose after getting 3 increments, your salary could have 10,000, and on the basis of it, pension amount would have been calculated. Now it has been calculated on the basis of 7,000.
No, initially from the date of from the date of issuance of the PPO, the authority has been calculated the revised pension. That revised pension is also less amount. That is also illegal, which is not been through the rule. That's why the petitioners has been approached and agitated to this honorable court that let them the provisional pensions may be because family pensions along with the other pensionary benefit is also lost to the petitioner. Even that the increment has already been that is been accepted. 3 increments have been stopped, that is accepted. Little punishment passed by the appellate authority.
Modified.
No affidavit has been filed by the state. as your lordship felt from the order.
Also, the present appeal has been preferred
পনেরো বাজে
Before your lordship rises, my lord,
Yes,
item number 19 and 20
yes, next day. will be-
appearing under the wrong heading, hearing heading.
You are there.
There were
19, my lord, I am
In 20, I am appearing for this status.
there were directions for filing affidavits, no affidavits filed.
In
Therefore,
stay application.
yes,
Stay application.
yes, yes.
Have you filed evidence?
my lord.
Which one? Your state?
19.
My lord, the state didn't want to file an affidavit. The school wanted to file an affidavit. Lordship had directed the same on the 25th of August. But this is appearing, yes. This is appearing under the heading hearing.
Item 17 to Dako.
My lord, I am for the appellant in this matter.
For the
Very
Civil Service
unfortunate.
Commission.
2021, there was a direction to give affidavit in opposition. Since 2021, I have not received the opposition.
It is a 2022 direction. At that period, I had just recovered from COVID, then I overlooked it.
4
And to
years.
extent, I will,
My lord, I do not stand in the way, but only one humble
yes,
request.
it is recorded in the order. It was
Recorded in the
adjourned on
order.
my ground because I was suffering from COVID.
What-
Few days
what is
later,
the
I joined.
It is regarding the appointment of
direction was given.
headmasters of first
Then
SLST
matter was not taken up.
2017. But there was rank illegality committed in the recruitment
Yeah,
process.
but Mr.
Only one request, my lord. My lord, a date may be fixed, my lord. Kindly, since 4 years, I am waiting for an
Mr.
affidavit.
Lairi learned
4 years you
it
did not take
appearing
any
for
step.
the appellate.
The vacation, may I have 3 weeks?
Okay.
Because the allegations are with regard to the entire selection process.
It will be delayed. Yes.
তাহলে by 15th করে দাও। It has to be because
To be.
you have to give it within the 15 to 18 because we are giving him an opportunity of 7 days. You have to file it before the vacation.
Yes, I will. I was praying for time till
আচ্ছা,
22nd. 3
আচ্ছা,
weeks
till
I was praying.
22nd December করে দাও। Reply thereto if any be filed by 9th January. Please the matter বলে দেবে on 12th January. Yes.
May I make
Deeply
one
obliged.
request, one humble
Yes,
request?
next matter.
Item 18.
তাহলে 13 January.
13 January. Very well, very well.
Yes, which are the applications পরের দুটো ডাকুন 18 19 কি বলছো
19 is my matter, 19 and 20.
you're for the that
My lord,
But 18, I am for the,
who is in 18
I am for the
State, my lord.
Huh.
18, I filed the affidavit in opposition as per lordship.
18 এর ফাইলটা দাও।
বলো, বলো।
You served the copy?
I have also served the copy.
My lord,
They have
appellant
not.
of the, my lord, appellant led by my lord Gaurav Das.
You have filed reply?
My lord, and this is why. My lord,
Not
the
yet.
No.
not, my lord, affidavit in reply is ready, but EPAM is not, required 7 days.
Why report? In view response.
কপি দিচ্ছি এটা ওনার কপি বলে নাকি?
You have, we did not call for any report. Why have you filed?
Affidavit, my lord.
Affidavit in
File a
opposition, my
report
lord.
in form of affidavit.
File affidavit in opposition to the respondent number 5.
Opposition already.
Opposition letter. Mr. Mondol, an advocate appearing for this. এই কপি দিয়েছে reply by 9th within a week, 16th, yes.
Lord, 19 and 20 are my matters, my lord. 25th of August, 2025.
We are rising, Mr. Banerjee. What do you want? Tell in a nutshell. You want
Lord, this is appearing under the wrong heading, my lord. Hearing.
show us. Have affidavits been exchanged?
No. My lord, the state never wanted to use an affidavit. The writ petitioners are not even contesting. The school wanted to use.
Well, at the instance of the writ petitioner, respondent number 1, the affidavit in opposition was sought for, and accordingly such direction was issued, my lord, on last occasion.
Respondent number 6.
Yes, Mr.
Respondent
Das,
number
what
1.
we have kept it after a week. Fine.
Lord, please see the order dated 25th of August.
Who is appearing for the school?
Mr. Shondeep Kumar De, Mr. Obijit Sarkar. They have not used any affidavit despite direction. My lord, the writ petitioners are not contesting.
I am led by Mr. Shondeep Kumar De, my lord. I am the respondent number 6, my lord.
Where is your opposition?
My lord, kindly extend a 2 weeks time to file in.
Lord, I am waiting since August, my lord.
Why you're not? This way it cannot be extended. Now, what is the reason?
My lord, he is the school. The writ petitioner is not contesting. The benefit has been given by the state. My lord, the very.
Who are you?
My lord, I am the then DI. The entire extent of interest has been directed to be deducted from my salary. And on the very first day without any affidavit. My lord, page 61 is the judgment under appeal.
There is no interim order staying operation of this order.
No,
The appeal.
that's what I have prayed in the stay application.
So you are still in service.
No, retired.
Now, what is the direction to deduct from your?
My lord, I am reading it. The interest that will be paid to the petitioner shall be recovered from the salary of the concerned district inspector of schools, for whose illegal arbitrary action there has been delay in according approval of appointment to the petitioner,
So that
resulting
was
in
heard in the
non-disbursement.
presence of you.
No,
It was not heard in your presence. Yes, then writ petition has no grievance.
Writ
Yes,
petition has no
what do
grievance.
you want to say?
My lord, I am not gifted in this matter, my lord. I am only instructed to
Hard Mr. Banerjee, learned advocate appearing for the your
Same set of appearance. Excepting
he's appearing.
state advocates are
In
changed.
20, I am appearing for the state respondents, my lord.
You are for the school.
Yes.
yes.
Same order.
Wait a minute.
Milord, so far as Milord 1 and 2 are concerned.
This matter, my lord, taken up after item number 3.
একটু বলার আছে না so far as item 1 and 2 are concerned, Milord, kindly recollect, Milord, on the last occasion I said I'll have to, all the trial court records were not there. So today I have come up ready with this supplementary affidavit. Copy is already served on the other side. So may I file, Milord, the supplementary
In
affidavit?
connection with which one?
1 and 2. WPLT 69 and WPLT 70.
Mr. Basu argued in which matter?
Item 3 will be continued. Will be completing today. Item 3.
No, you made part argument in item 3. No?
Item 3.
1, 2 has not been opened because my point was that both are identical point are there.
Achha, achha. 1 and 2. No, no, the Mr. Basu, we will hear you. You will check up those applications.
I have already served upon the others. I have already served.
He is assuring nothing is new. I will not. I will rely on it.
এই 3 নম্বরের ফাইলটা দাও।
আচ্ছা, এটা 69, ওটা 70। হ্যাঁ, ওটা কোনটা গেল? 70টা গেল। কি করে দিতে হয়? হয় কি ধরনের কথাবার্তা? একটু আলাদা করে নিন তো, 69 দুটো হবে, 70 ওরা একসঙ্গে করে দিয়েছি। 69 70 করে একটা একটা করে 69। হ্যাঁ,
My lord, in item 3, my lord, I am appearing for state, my lord, led by Mr. Galib. I'm sorry, my lord, I am due to my ill health, I could not appear physically.
she is with me, Lord. Lordship, may I start, Lord?
Yes.
My Lord, my learned senior friend, argument, my Lord, so far as I have understood, there are 3 pillars of the argument. One is that চারটি আছে। The first pillar of argument is, my lord, that his vendors are non-agricultural tenant. So since non-agricultural tenancy was outside the purview of West Bengal State Acquisition Act, the question of vesting does not arise under the State Acquisition Act. Second limb of the argument was that yes, mutation already done in the name of the petitioners, the clients of my learned senior friend. The third limb is in the RS record of rights, there is a remark column. In the remark column, it is written Boshot Proja. My learned senior friend has referred to page 136 of the writ petition, which is a circular, my lord, by the government in the year 1994.
136 of the
Writ petition, lordship. It's a circular of 1994 by the Director of Land Records and Surveys.
Yes.
The contemplation of this circular is this, that Boshot Proja shall be regarded as non-agricultural tenant in contemplation of section 3A of the Land Reforms Act. And the last limb of the argument is that it was a retained land of my vendor.
Yes.
My lord, before embarking upon the respectful reply, my lord, to the arguments of my learned senior friend, may I, my lord, give the bird's eye view of my contention. My respectful submission is that the vendor of the petitioner cannot be regarded as a non-agricultural tenant, but he was an intermediary.
Yes.
So intermediary's land got vested by conjoint operation of section 4 and 5.
Yes.
Third respectful submission is, lordship will find from my lord the record, RS record of rights, that the classification of the land is go down. So in the light of this, my respectful submission is that it's a land under section 6 estate acquisition. G, it's a mill. Hence, the retention is subject to section 6, subsection 3 of the Estate Acquisition Act. Because it was a land comprised in the factory mill. So, my lord, with regard to the first leave of my submission, if I may respectfully invite your lordship to the mother deed. That is, my lord, at page, my lord, 45.
What is that?
Page 45 is a deed of the vendor of the petitioner. Vendor of the petitioner.
Yes.
Lordship, if I may respectfully invite your lordship. Lordship, sorry. We'll have page 45 of the writ petition. This is a deed of 1938. Lordships may kindly, my lord, if may start from page 45, my lord. The indenture made this 22nd day of September 1038 between West Press Limited, private company duly incorporated under the Indian Companies Act, called the vendor.
Where you did it?
My lord, page, my lord, 45, my lord.
Yes.
This is the, my lord, deed of the vendor of the petitioner. The indenture is of 1938. Kindly see, my lord, what does it say? Indenture made this 22nd day of September 1038. Now page 46. Vendor of the one part and Howler Trading Company Limited having the registered office at so and so year and for a purchaser of the other land, whereas the vendor is seized and possessed of and absolutely entitled to the lands, hereditaments and premises comprised in the schedule hereunder, whether and delineated in the plan hereto, annexed subject to the payment of rents and cesses payable in respect of the tenure upon which the same are respectively held, and all the jute press and other buildings erected and built thereon, or on fault thereof, and also the fixture and fittings of pertaining thereto lying in or upon. The vendor both agreed with the purchaser of the absolute sale to them of property, desired free from encumbrances, rates and cesses payable in respect of so and so, pursuant to the said arrangement in consideration of payment to the vendor by the purchaser of the sum of rupees 70,895 only. The vendor both hereby admit on and from the same and every part thereof, acquit, release, and favor discharge. The vendors both hereby indefeasibly grant, convey, transfer the assign unto the purchaser all those pieces and parcels of land being premises number 28, 28 by 2, 28 by 3, 28 by 4, 28 by 5, 28 by 6, 28 by 7, and 28 by 8. May I just point to the relevant part of the deed, my lord. Kindly comes to page 47.
Page
47.
Yes.
What was the sold portion, the parcel of the land, my lord? Kindly see page 47, my lord. 1, 2, 3, 4, 5, 7, my lord, lines from the top. Together with dock, boiler, and press houses and all other erections and buildings of every kind, including storeyards, bungalow, open side jetties, and darwan's quarters, erected upon the said premise or piece and parcel of lands and belonging thereto and used occupied therewith, and all other yards, drains, paths, passages, water recourse, benefits, advantages of ancient and other lights.
Very good. What is your argument?
So, my argument is this, my lord. This entire deed, which is the deed of the vendor, the petitioner will show that there was a mill, and my lord, he was an intermediary. This, my lord, is a property subject to, my lord, section, my lord, 6, my lord, 1, G, my lord, of the State Acquisition Act.
That he was an intermediary, what you were referring to?
Intermediary.
So it is coming, intermediary.
It is a revenue paying land, firstly.
Yes.
Lordship has got, it's a revenue paying land.
Yes, we have seen that.
So if it is a revenue paying land, my lord, the definition of the state, the definition of the estate as given in the Bengal Tenancy Act, because Estate Acquisition Act says that definitions and expressions which are not defined in the Estate Acquisition Act are to be borrowed from the definition expressions of Bengal Tenancy Act. So in the Estate Acquisition Act, my lord, we don't get the definition of what is estate. So for estate definition, my lord, you have to go to Bengal Tenancy Act. Kindly see Bengal Tenancy Act, lordship. What does the definition of the state say? In the Bengal Tenancy Act, my lord, that is section 3, my lord, subsection 4, my lord, section 3, subsection 4, my lord, of the Bengal Tenancy Act, estate means land included under one entry in any of the general register of revenue paying lands and revenue free lands, prepared and maintained under the law for the time being enforced by the collector of the district, and includes government khash mahols and revenue free lands not entered in the register. So revenue paying land and revenue free land. Revenue free lands are Lakhiraj, Shivottor, Devottor, Brahmottor, Shiragi, Wakaf. So revenue free lands and revenue paying lands were the definition of estate. Section 4 subsequents and the rights therein. Kindly see me note section 4(1) next of the State Acquisition Act. Section 4, subsection 1 of Estate Acquisition Act.
Yes.
May I read out, my lord? Notification vesting estates and rights of intermediaries. The state government may from time to time, by notification, declare that with effect from the date mentioned in the notification, all estates and rights of every intermediary in each such state situated in any district or part of the state shall vest in the state free from all encumbrances. So, my lord, estates means revenue-free lands and revenue-paying lands. The vendor of the, my lord, the petitioner was purchased a revenue-paying land from his seller.
Yes.
And secondly, lordship, that reciters in the deed show that it was a land comprised in the mill factory. My lord, may I respectfully invite your lordship now, the definition, my lord, the next provision of section 6, my lord. Section 6, my lord. Subject to the provisions of subsection 3, land comprised in mills, factories, or workshops. So, my lords, it is not only the mill proper, even the lands comprised in mill.
That is section 6.
1G.
Yes. This is your first argument.
Comprised in. So, my lord, the mill proper, apart from that, the lands comprised, it comprises the particular meaning in the Oxford Dictionary. Lordship knows that, lordship. It encompasses. So, my lord, that is 6.1G. Now, lordship kindly sees, my lord, 6.1G says, subject to the provision of subsection 3. Kindly see subsection 3, my lord, of section 6, my lord. Subsection 3 says, my lord, in the case of land comprised in a tea garden, mill, factory, or workshop, the intermediary or where the land is held under lease, the lessee, shall be entitled to retain only so much of such land as, in the opinion of state government, is required for the tea garden, mill, factory, workshop, as the case may be. And the person holding under lease shall, for the purpose of assessment of compensation, be deemed to be an intermediary. Provided that the state government may, if it thinks fit, so to do, after reviewing the circumstances of a case and after giving the intermediary or the lessee, as the case may be, an opportunity of being heard, revise any order made by it under this subsection. And thereafter, explanation 1 and explanation 2 speaks of resumption the moment there is change of user, fails to use or ceases to use. So, my lord, in the language of subsection 3, my lord, subject to lordship's correction, that the person who holds a land under section 6, subsection 3, he is a retainer, not a rayat. Retainer does not have a marketable title to transfer his property. In this context, my lord, may I respectfully invite your lordships, my lord, to section 4, my lord, subsection 1, my lord, clause C, my lord, of the Land Reforms Act. Lordships, section 4, subsection 1, clause C says, rights of riot in respect of land, that is section 4, subject to the any other provision of this act, a riot shall, on and after the commencement of this act, be the owner of his plot of land, and the plot of land shall be heritable and transferable. Now, my lord, clause C says, explanation says, for the removal of doubts, it is hereby declared that any person or institution who holds any plot of land, A I am skipping, my lord, B I am skipping C, under Shariat interest,
yes,
or by retaining such plot of land under clause G, or under clause F of subsection 1, read with subsection 3 of section 6 of West Bengal Act, shall not be a rayat for the purpose of this subsection. So, my lord, the land being held under subsection 3 of section 6 is a retainer, not the rayat. Hence, it is neither heritable nor transferable. And this retainer, my lord, if he fails to use or ceases to use, then, my lord, there is a power of resumption that is under,
No, no.
Manual Land Reforms Act.
Estate acquisition.
that is in explanation 2 of estate acquisition.
Tone of water ইয়েতে আছে, chamber.
That apart, my lord,
The here transfer was effected in 1938.
no, here transfer was effected by this purchaser Howrah Mill to the petitioners in the year 2010. That deed, my lord, is at, my lord,
Showing us a
page
deed
80.
is 38. 38.
My vendor.
Lordship, petitioner,
West Press Salkia sold out to Howrah Trading Company.
yes,
Before promulgation of Estate Acquisition Act.
Lordship. Lordship.
So it would be treated as a non-agriculture land held by Howrah Trading Company on the date of vesting.
My lord, vesting comes, my lord, on a particular date, 1 day vesting. Vesting comes under the Estate Acquisition Act. That is 1 day vesting. Section 4 notification. So, my lord, it allows retention so far as non-agricultural land is concerned. That is 15 acre
15 and 5, homestead 5, 15,
and 5.
non-agricultural.
So 20, that is 25 agricultural.
25.
Now, so these retentions, my lord, the intermediary or Riot Chapter 6, they will have to go to the revenue officer. That is, Gaur Gopal Mitra says this, that he'll have to go and exercise his power of retention. Then, until possession taken, you can exercise your power of retention. That is, my lord, with regard to the retention of lands under subsection 6, subsection 1, A to E.
Mr. Galit, if it is before date of vesting, then it would be treated, it is a non-agricultural land, admittedly, and it is being held by, it was being held by Howrah Trading Company.
Lordship.
So you can get the land if you say that it is beyond prescribed limit under section 6(1),
Lordship.
beyond the prescribed limit, non-agricultural land.
Intervene for a
Or
second.
he was allowed to retain it under section 6(3).
Only one sentence, not even sentence. Can you take a note? The land is 10 bigha. That's all. 10 bigha.
10 bigha, yes.
Can you keep it a note?
Yes, I have seen.
My lord, 10 bigha land, if it is treated as my contention is that so far as retention part of section 6, subsection 1, A to E is automatic, he has to go. But so far as retention of F and G are concerned, it is subject to section 6(3). The retention part, as it is said in other subclauses, are on different footing with regard to the retention part, which are contemplated in clause F and clause G.
Suppose, Mr. Galib, I have certain 1 bigha, 2 bigha land, which is within 10 acres, 15 acres non-agricultural land. I am using the said land to run a mill and factory. Can you acquire it? Only for the reason.
In my, I fully may not understand your lord.
Although I am holding the
I am lordship.
non-agricultural land within ceiling limit, and only for the reason that I am using
Lordship.
this as a mill.
In my,
Acquire.
yes, in my respectful reply to the query of the Honorable Court, my lord, Lordship, my lord, when the Estate Acquisition Act promulgation took place, the entire account of land of an intermediary across Bengal were taken into consideration, not a particular land.
Yes, yes, yes.
So, my lord,
15,
if from my lord,
Estate Acquisition Act to be.
if from my lord, here we find from one deed,
One we can share.
what Estate Acquisition Act?
Yes, yes. Yes,
আরেকটা আছে, আরেকটা লাগলে-
Okay, we shall hear you. We shall hear you. Note down. Yes.
So, my lord,
Trying to give the book to my lord.
enter account of land of an intermediary across Bengal were to be taken into consideration with regard to the ceiling limit of agricultural land and non-agricultural land. So here we are only on one deed of the purchaser, that is Howrah Trading Millard Company. So here, my lord, assuming that if this particular land is to be taken as a non-agricultural land of Howrah Trading Company, my respectful submission would be that non-agricultural land category will not be taken into consideration, because here the entire recital is of a meal factory. So it will come within the periphery of G and not Miller C. It will come within the category of G and not C.
Yes. Yes, yes, yes.
So, my lord, this, since it's clause G which is in operation, hence, my lord, subsection 6.3 will have to. Not only that, even subsection 3 has several fetters have been put in the LR Act also, that you cannot do it all these things with regard to 6.3 land. If I may respectfully invite your lordship to 14Z. Kindly see 14Z, my lord, of the LR Act. (14Z), my lord, of the LR Act says, my lord, for the removal of doubts, it is hereby declared that notwithstanding anything contained in this act or any other law for the time being in force, agreement, custom, usage, or decree, judgment, decision, or award, this chapter shall apply to all lands of all classes and descriptions defined in clause 7 of section 2, provided that nothing of this section shall apply to the land possession of which has been allowed to be retained under clause G or under clause F of subsection 1, read with subsection 3 of section 6, notwithstanding anything contained in any other law for the time being in force. So, my lord, if, my lord, the section 6 subsection 1 has given definite categorization, homestead, buildings with structure, non-agricultural land up to 15 acres, then comes fishery, tank fishery, then comes held by corporation, cooperative, then comes tea gardens, orchards, then comes mill factory, my lord. So, if the mill factory, today also there is an attempt in some other proceedings that hard bazaar shall also be taken out of the purview of West Bengal State Acquisition Act by taking it that into consideration as a non-agricultural land. So, my lord, if, my lord, mill factory workshop separate provision, non-agricultural land clause C together with homestead 20 acres, you keep it.
Yes.
Yes, yes.
My lord, I have also referred to one judgment, my lord.
No, you just remind us about the tribunal's version.
Tribunal's version, my lord. If I may respectfully invite your lordship, my lord.
Page 289.
289, my lord. My lord, may I respectfully invite your lordship to the observation part. My lord, observation part, my lord, starts, my lord, from page 293, my lord, internal page, my lord, 5, my lord.
293.
293, my lord. The extent of applicability of the Non-Agricultural Tenancy Act 1949, as mentioned in section 1, has been specified, wherein it has been specifically mentioned that the West Bengal Non-Agricultural Tenancy Act 1949 extends to whole of West Bengal except the area to which the provisions Kolkata Thika Tenancy Act applies. The applicability of the Kolkata Thika Tenancy Act, as mentioned in section 1 of the said act, has not specified wherein it has been specifically mentioned the Kolkata Thika Tenancy Act 1949 extends to Kolkata as defined in clause 11 of section 3 of Kolkata Municipal Act 1929 and to the municipality of Howrah. Accordingly, there is no doubt that the provision of West Bengal Non-Agricultural Tenancy Act 1949 cannot be applicable within the area of Kolkata Municipal Corporation and Howrah Municipal Corporation. The case land, as mentioned herein above, falls within the jurisdiction of Howrah Municipal Corporation, and accordingly, in terms of Section 1 of West Bengal Non-Agricultural Tenancy Act 1949, the provision of West Bengal Non-Agricultural Tenancy Act cannot be applicable. That is observation 1. Second observation, my lord, the West Bengal Land Reforms Amendment Act 2007 came into force with effect from 15 May 2017, wherein there is a provision of amendment of Section 4B of said Act. In Section 4B, subsection 2 was renumbered and inserted wherein a specific provision has been made as follows. Milord, 4B2 is, Milord, of the LR Act is that the transferee of a retainer can be a lessee. That is 4B2, Milord. The 4B2 has been, Milord, quoted. Now, Milord, kindly see the next paragraph. In view of such specific provision of the above mentioned act, the applicant is undoubtedly the retainer of the land under Section 6.3 with effect from date of vesting under West Bengal State Acquisition Act, that is on and from 15th April 1955 or 14th April 1953 as the case may be, or from the date of such transfer as the case may be in terms of provisions of Section 14Y excluding tea gardens in terms of said amended provision. The company was merely a retainer of the case land. Such retainer can transfer only such right or interest to his vendor which he had. The annexure deed, the title deed of the applicant with a page number so and so onwards is very much clear on that point at page 55. The applicant was interested to purchase the case land from the first party company, Howrah Trading Company Limited, as is where it is basis. The Howrah Trading Company cannot confer the applicant company better title than that he had. The fact remains the case land is 6.3 land with effect from the date of vesting of West Bengal State Acquisition 1953, and therefore the transferor company can transfer only his right title interest in the case land which he had. In observation number 3, my lord, in support of his contentions, the applicant has cited a decision reported in 2017 SCC Online Cal, that is, my lord, Jui Finales. With the case involved is situated at Mauja Shahanpur, District Howrah. As per document filed by the state respondents, it appears that one review application is pending against the said judgment cited above. Accordingly, until and unless the review application is disposed of, the said decision cannot be relied on. Accordingly, the above decision is not squarely applicable to the present case. The applicant cited another decision reported in 2012 Online Calcutta, in which the land comprised in tea garden is the subject matter. Accordingly, the said land does not fall within the jurisdiction of KMC or HMC. Accordingly, the said decision is also not squarely applicable in the present case. Next, my lord, observation 4. The applicant has shown one mutation certificate with the annexure E of the report of the application. In continuance of this proceeding, direction was given to the applicant to file the certified copy of the constituted proceeding of the same mutation case, but the applicant has failed to file certified copy of the mutation proceeding. Only he has filed certain documents, namely application for mutation, etc., which does not bear the seal and signature of office. Accordingly, the said unsigned documents are treated as unofficial and cannot be entertained. Next, my lord, observation 5. In view of the legal position, we have no hesitation to hold that being the retainer of a land, the company cannot have any jurisdiction to transfer title in favor of the transferee simply on the ground that the state of West Bengal is the actual owner. The Section 60 land, we do not find infirmity in the ADM law. So, my lord, purchase was on the basis of as is where is basis. It is clearly stated in the, my lord, in the deed of the petition. That one lordship kindly sees, my lord.
Yes, that has been given.
Lordship. So, my lord, my next submission is, my lord, respectful submission is, my lord. So, it's an intermediary, so it stays vested. Article, my lord, my argument on that basis, my lord, is also on the basis of, my lord, the Article 31A of the Constitution of India. My lord, Article 31A of the Constitution of India, my lord, has clearly spelled out the meaning of estate. On the last occasion also, my lord, I did argue on this issue, my lord, and I cited a judgment also, my lord, Article 31A of the Constitution, my lord. It is about
Constitution to be with
clause 2, lordship.
Yes.
My lord, may I respectfully invite your lordship, my lord, to clause 2, my lord, of Article 31, my lord, A of the Constitution of India. In this article, clause 2, my lords,
Yes.
A, the expression a state shall in relation to any local area have the same meaning as that expression or its local equivalent has in the existing law relating to land tenure in force in that area, and shall also include Roman 1, Roman 2, my lord, may I read out Roman 3. Any land held or let for purposes of agriculture or for purposes ancillary thereto, including wasteland, forest land, land for pastures or sites of buildings and other structures occupied by the cultivators of land, agricultural laborers and village artisans. The expression rights in relation to an estate shall include any rights vesting in a proprietor, sub-proprietor, under-proprietor, tenure holder, riot and under-riot, and other intermediary, and any rights or privileges in respect of land revenue. So, my lord, if, my lord, we go through the, my lord, the definition, my lord, of, my lord, the intermediary, my lord, as given in the State Acquisition Act, my lord. Intermediary, my lord, it is section, my lord, 2, my lord.
2I.
Clause I. Intermediary means a proprietor. Tenure holder, under tenure holder, or any other intermediary having above a riot or a non-agricultural tenant. This is a escape route which has been going on since long, my lord. So, my lord, intermediary means a proprietor, tenure holder, under tenure holder, or any other intermediary above a riot or a non-agricultural tenant, and includes a service tenure holder, and relation to mines and minerals includes a leasing, subleasing. Now, my lord, clause, my lord, J, my lord. Now, clause K, my lord. Who is a non-agricultural tenant? Non-agricultural tenant means a tenant for non-agricultural land who holds under a proprietor. So, my lord, if intermediary is a proprietor and non-agricultural tenant is under the proprietor, and my lord, kindly see section 4.1. Section 4.1, when it in clear unequivocal term, it says that the state government may from time to time by notification declare that with effect from the date mentioned notification, all estates and rights of every intermediary in such a state situated shall free from all income shall waste. So, my lord, when all the proprietary rights of an intermediary, my lord, in respect of an estate, my lord, and the rights, my lord, included therein, stand, my lord, vested by dint of promulgation of section 4, my lord, and 5 conjoint operation. How, my lord, a person who is, my lord, under a proprietor claims that his property does not stand vested or his right does not vested? This is exactly, my lord, the language of Anjan Basu. That we don't want to buy your argument. The non-agricultural tenancy got vested only in the on and from 1980, not until then. But proprietary rights of an intermediary already stood vested in the year by dint of operation 1953. Ratnagiri in one of the paragraphs says specifically there is no relation between the acquisition under the State Acquisition Act and Land Reforms Act. So, my lord, my respectful submission, my lord, when estates and rights of an intermediary, my lord, in the light of Article 31A of the Constitution of India, stood vested a person, my lord, who is claiming that is non-agriculture tenant, which my learned friend's argument is, under a proprietor, cannot be immune, my lord, from that vesting.
Yes.
My lord, may I next take your lordship, my lord, to my lord, the Non-Agricultural Tenancy Act, my lord, 1949.
By Article 31A2, what did you want to point out? That is the estate definition which has been given.
It is wider enough, my lord, to include.
Wider enough to incorporate this.
Lordship. As I have also cited one judgment on the last occasion, long before it was.
Yes,
I will show that. That is, my lord, of 1960 AIR 1962 AC 694. Paragraph 1, 26 to 29, 33 to 35. Here also, my lord, there was an attempt.
এটা একটু দেখো এর ভেতর কপি দিয়েছিল কিনা। Yes, next point.
So, my lord, here also there was an attempt, my lord, to show, my lord, that certain category of lands was outside the purview of a state. The contention of this, the petitioner, Nambudiri Pado, was that I have been paying the rent directly to the state. So, since there was no intermediary between the estate and the tiller of the soil, because I am paying the rent directly to the state, so no intermediary in between. So, these categories of land shall be taken out of the purview of the state definition, Article 31A. Here exactly what the non-agricultural tenants are trying to do, my lord. Next, if I may respectfully take your lordship to Section 5, my lord, Clause C. Section 5 of Estate Acquisition Act, my lord, Clause C. Of the Estate Acquisition Act, lordships. My lord, Section 5 is the effect of Section 4. Now, kindly seize, my lord, Clause C. Subject to the provision of subsection 3 of Section 6. Every non-agricultural tenant holding any land under an intermediary, and until the provisions of Chapter 6 are given effect to, every riot holding any land under an intermediary shall hold the same directly under the state, as if the state has been the intermediary and on the same terms and condition as immediately before the date of it. This particular clause C, my lord, was inserted in the West Bengal Estate Acquisition Act in the year 1964. It was not there originally. So, since here, my lord, it is one of the arguments in several line of judgments that on the date of promulgation of Estate Acquisition Act, this non-agricultural tenants became direct tenants under the state. They have been paying rent to the state. Hence, their tenancy right cannot stand vested. That is exactly the point which has been taken care of by 1962 judgment.
Yes.
My lord, my next full submission on the point of law again is kindly comes to, my lord, the NAT, my lord, the West Bengal Non-Agricultural Tenancy Act 1949.
No, that.
West Bengal authority comes and says this. That-
Known to be, my lord, could appreciate it. Nowadays, application is such.
Well,
After
no,
some
no.
time, my lord, forget what is
Sorry.
And I,
No, I'm sorry, Lord. It's
we also appear before Justice N.K. Mitra. I could have, what will happen if he is alive today? One gentleman is saying, advocate was saying, my lord, my AD. চমকে গেলাম
Milord, may I respectfully invite your lordships, Milord, to the definition of non-agricultural tenant. Milord, section 2, Milord, subsection Milord 5. Section 2, Milord, definition clause 2(5).
Non-agriculture land, a tenant.
Tenant means
And is having
lordship.
oh, yeah, take it.
Bear বেরিয়ে গেছে
এই বইটা হবে হ্যান্ডেল বলতে যাচ্ছি tenancy act 1949
Created direct tenant way. Definition
section 5
2(5).
Section 2, Milord, clause
Definition clause, section 2.
definition clause below section 2, Milord, clause 5. Non-agricultural tenant means a person who holds non-agricultural land under another person and is or but for a special contract would be liable to pay rent to such person for that land, but does not include a person who holds any premises or part of any premises situated on non-agricultural land and erected or owned by another person, and who is or but for a special contract would be liable to pay rent for such premises or on such part of the premises to such person. Now, explanation, my lord. In this clause, premises means any building, so it does not include. In this clause, premises means any building such as a house, manufactory, warehouse. Warehouse. Lordship, if your lordship may kindly come to the RS record of rights which has been annexed, my lord, at page, my lord, 180. The 181, lordship.
Yes.
It says Gudam. Kindly see the classification. Dark 368 by 423 is Gudam, Howler Trading Company Limited. So Gudam is a synonym of warehouse. And clause 5 says it does not include.
yes
Milord, I have already argued, Milord, comprised in is the word used in 61G. Comprised meaning, Milord, Lordship, Milord, is given. Comprised in Oxford Dictionary, Milord, says, Milord, include, consist of, be composed of. So, Milord, in my respectful submission, it is not only the mill or factory proper, even the lands comprising thereto. So, that is the language comprised of.
Yes.
Now, Milord, if I may respectfully invite your Lordship, Milord, to Milord, Section 3, Milord, A of the Land Reforms Act. Milord, Section 3A, Milord. Rights of non-agricultural tenants and under tenants in non-agricultural land to vest in the state. Rights and interest of all non-agricultural tenants and under tenants under West Bengal, non-agricultural tenants and 1949 shall vest in the state, free from all encumbrances. And the provision of Section 5 and 5A of West Bengal State Acquisition 1953 shall apply with such modifications as may be necessary, mutatis mutandis, to all such non-agricultural tenants and under tenants, as if such non-agricultural tenants and under tenants were intermediaries and the land held by them were estates and the person holding under a non-agricultural tenant or under tenant were a riot. Now kindly comes to explanation. Nothing in Section 5 and 5A of the West Bengal Estate Acquisition 1953 shall be construed to affect in any way the vesting of the rights and interest of a non-agricultural tenant or under tenant under West Bengal non-agricultural tenants and in the state under subsection 1. So if it is assuming but not admitting that if vesting of the non-agricultural tenancy is to be considered with effect from Milord 9 September 1980 when Section 3A has been engrafted in the LA Act and not before, in my humble understanding from the explanation, that is, it is a continuation of the process which had already taken effect under Section 5 and 5A of the State Acquisition Act. Nothing shall be construed to affect in any way the vesting of the rights and titles on non-agriculture under subsection 1. Now, Milord, Section 3 of the State Acquisition Act, Milord, gives overriding effect. And, Milord, Section 3, Milord, the State Acquisition Act, Milord, kindly have a look, Milord, if I may respectfully invite your Lordships, Milord. It gives overriding effect of this Act. Section 3, Milord, the provisions of this Act shall have effect notwithstanding anything to the contrary contained in any other law for the timing, or any contract expressly implied, or in instrument notwithstanding, provided that nothing in this Act shall apply to any land held by corporation. Pray further. So it has an overriding effect. Not only that, Milord, even the preamble to the Act has undergone a change. A part of it in the year 1961. Kindly seize me the preamble to the Act of West Bengal State Acquisition Act. Prior to amendment, an act to provide for the state acquisition of estates, of rights of intermediaries therein, and of certain rights of riots and under riots. Up to this was the original preamble. And of the rights of certain other persons in lands comprising the states, and of the rights of certain other persons. This was later added in the year by the Amendment Act of 1961. So includes all.
Yes.
Mirror Boshoth Proja in the remark column of the RS record of rights. Millard by Dean to Millard, page Millard 136 of the writ petition, Millard says Millard that it is to be regarded as non-agriculture tenant under section 3 of the Land Reforms Act. Millard Boshoth Proja remarks column. Millard, if I may pose this question to myself, in which record of rights? In the RS record of rights. Millard, RS record of rights prepared Millard by dint of chapter Millard 2 and chapter 6 of the State Acquisition Act. To my first despicable submission, from nowhere does this come that in the RS Porcha, where Boshoth Proja is written, it is to be regarded as a non-agricultural tenant. Nowhere does it come from. 136 circular at page Miller kindly sees.
Yes.
It speaks of Land Reforms Act. Kindly sees, Millard, if I may respectfully trouble your lordship once more, Millard. If your lordship may, Millard, have a look, Millard, at page 136, Millard. I am taking much of your lordship's judicial time, Millard. Kindly pardon, Millard. 136, Millard. Circular dated 14 September 1994 at the bottom. Kindly sees, Millard, what does the circular say? In supersession of all previous circulars, instructions relating to accounting and vesting of non-agricultural lands, it is clarified that all non-agricultural lands belonging to erstwhile intermediaries and riots shall vest, if found excess, to the state with effect from 15th February 1971. May I pause for a moment? 15th February 1971 is reference to Chapter 2B of West Bengal Land Reforms Act. Preamble of Land Reforms Act says, consequent upon vesting under state acquisition, now I am coming to land reforms. So agrarian reforms has already taken place under West Bengal State Acquisition Act. Now comes next chapter, Milord, land reforms. So that's why, Milord, if your lordship goes through the preamble of the Land Reforms Act, Milord, it says, Milord, that an act to reform the law relating to land tenure consequent on the vesting of all states on certain rights. That's why, Milord, riots under chapter 6 suffered vesting under State Acquisition Act. Again, those riots is suffering a vesting under chapter 2B in respect of ceiling limit as contained under section 14A. Read with 14K, that is family. So it is a land reform which is consequent of agrarian reform took place under West Bengal State Acquisition. So, Milord, kindly, Milord, if I may pause. So, Milord, with effect from 15 February 1971, under section 14A, that is vesting under chapter 2B of West Bengal Land Reforms Act 1955. To remove all doubts and confusions, the statutory provisions are explained below. Section 3A is taken into account. Now, what does it say? Clause 2, exclusively non-agriculture tenants like Dokholkar, Chandima, Dokholkar Boshoth Proja of all grades are outside the purview of West Bengal Land Reforms Act and were exclusively guided by West Bengal Non-Agricultural Tenancy Act 1949, herein so and so. It does not at all refer to the, Milord, the record of rights prepared that the remarks column, if any, in the RS record of rights. Since my contention is, Milord, this particular land go down is outside the purview of West Bengal, Milord, Non-Agricultural Tenancy Act. I've read, Milord, that go down is this. My second full summation with regard to 94 is, it's a circular 1994. And the porcha is of, Milord, 1956 post. So circular of a government cannot have any retrospective effect as supported by Supreme Court judgment.
Yes.
Milord, West Bengal Non-Agricultural Tenancy Act 1949, Milord, did not have any operation, Milord, in the jurisdiction of Howrah Municipal Corporation. So there is no question of its applicability apart from the arguments which I have made, Milord, prior thereto. Apart from my understanding of section 5 of section 2, subsection 5 of section 2, that godown does not include non-agricultural tenant. In addition to my second respectful submission is that non-agricultural tenancy act was not applicable to the place. This is Howrah. It is clear from the Milord. The section 1 of 1949 Act. It says subsection 2, it extends to whole of West Bengal except the area to which the provisions of the Calcutta Thika Tenancy Act 1949 apply. So, Milord, Calcutta Thika Tenancy Act was applicable to Howrah. So, this was not applicable. Milord, my next respectful submission is that there is a point taken, Lordship will find, Milord, from the observations made by the learned tribunal in the impugned judgment, that the BT Act was not applicable to Howrah. There was an argument. Milord, what we are on is not Bengal Tenancy Act, we are on West Bengal Estate Acquisition Act. We are, Milord, clamoring on the point, Milord, that the vendor, Milord, of the Milord, the petitioners, Milord, are intermediaries as contemplated in section 61G. He was the retainer, not a Rayat. And West Bengal Estate Acquisition Act does not repeal Bengal Tenancy Act. Bengal Tenancy Act is repealed by West Bengal Land Reforms Act.
Yes. Yes, records are there.
No, Milord. RS purchase there.
On the record?
180.
Yes, is there.
Is the RS.
RS 180, Lordship.
Page 48, come to page 48, schedule. Morosi Mokrori.
Morushi is generation to generation. Mokrori fixed rent.
It is a permanently settled to a tenant.
Fixed rent, Milord.
By the big.
It is a Sthitiban.
It is a permanent settlement given to a tenant by the big Rayat.
By the?
Big Rayat.
Mokorori, Morushi, Milord, so far as the glossary go, we have the glossary in BT Act. Lordship, may I show, Milord?
A permanent and heritable tenancy given by the big Rayat.
I think, Milord,
to its tenant. Now come to page 6, section 6.
Lordship.
Six 1C. 6.1c. Non-agricultural land in his khas possession, including land held under him by a person, comma, not being a tenant. So the non-agricultural land held by the tenant will not come under purview of section 6. If the Howrah trading become a tenant anywhere under any big Rayat, he will not come under 6C. I am seeking clarification from you. Don't take it otherwise. So that tenant will not come. And intermediary, everyone, under section 52, everyone was intermediary. But where intermediary under section for the purpose of section 4, 5, 6, that intermediary is total. And non-agriculture tenant under non-agriculture tenant 1949 and non-agriculture tenant under State Acquisition Act, there is difference. So why two act?
But Miller, our
Because you are allowed to run, allowed to remain in operation for a particular till section 3A was introduced, incorporated. Why? So two tenants are different. Non-agriculture tenant under non-agriculture tenancy act and non-agriculture tenant under State Acquisition Act, two different. And hence legislature allowed two different act to remain in operation till section 3A was incorporated in Land Reforms Act.
Milord, 1980, Milord, I shall show Milord. Arun Basu is very much clear. Milord, proprietary, the tenant is under a proprietor. Who is a tenant? Definition is given in BT Act. So, Milord, if a tenancy right is under a proprietor, and if the proprietary right goes by dint of operation of an act, how can he, Milord, subsequently may pose this question to myself? He remains, that means, Milord, today, Milord, in the guise of non-agriculture tenant, an intermediary will come and claim everything. And this is exactly what is happening, Milord. Hard bazaar, now being shown as non-agricultural land category, it will come. So 15 acre, we have kept it, you can't do it, you can't take it. There is no automatic vesting. But in section 16 compensatory rule, special provision that you can take compensation for hard bazaar, all these things are there. Section 5(1) is very much clear. So rent receiving power of the intermediate zamindars were abolished. Rent receiving power or revenue receiving power. That is why when the state says the revenue free land and revenue paying land, all I would take for Jamindari abolition and the permanent settlement as contemplated by Lord Cornwallis. So if that be so now from intermediary, the non-aggregate tenants are being segregated. Now those intermediaries who got caught under 1953 Act, they are coming in the guise of non-agriculture tenants and getting themselves released from the operation of 1953 Act. This is what is happening.
the judgments which Mr. Basu has referred, how that is
So
not.
I have completed. I have almost completed, Lordship. I have almost completed, Miller. So, Lordship, only Miller thing I would refer.
So you summarize your argument. You
Summarize this, Milord. So that is on the part of intermediary and non-agriculture tenants. So only last reference I would like to make, Lordship, that Lordship kindly consult also, Milord, that when intermediary definition of West Bengal Estate Acquisition Act,
that you have said.
proprietor part definition BT Act, and tenant definition also in BT Act. So Lordship kindly consult, Milord. So in my humble understanding, he should be considered an intermediary. I mean the seller of the Milord, the vendor of the petitioner. So, Milord, second. Only, Milord, one thing, Milord. There might be a question that if mutation was already granted to the petitioner, that is page 101. Then why was he for the second time? One of the contentions of the petitioner is that we were granted mutation in the year 2010. Then my question is, why were you for remitting the second time? So 2010 mutation certificate, Milord, is at page 101.
101
of the writ petition. Our reply thereto is, Lordship, kindly write down only that will serve, because it's on fact, Lordship. Our reply thereto is at page 220 and 221. That is opposition used by the state before the learned tribunal. Now, why second time? Second time is nothing but, Milord, if your Lordship, Milord, kindly comes, Milord, to Milord, page 35, second time is for conversion. Second time is nothing but for conversion that will appear from his original application, averment in the original application. That is at page 35, specific grounds, Milord, I am showing your Lordship. Page 35, Rome 8. The applicant states that for alteration in the mode of use of the said lands, it approached the concerned respondent for obtaining permission for change of area, character, use of land. It was verbally communicated by such respondent that it would not accept the mutation certificate issued in the year 2010, but the applicant should obtain certificate by an online procedure. Thereafter, the respondent would issue a conversion certificate. So, this was the issue. Now, judgments, Lordship.
Now that second mutation rejection order is page?
Second mutation rejection order is, Milord, at page, Milord, 110. 110, Milord.
Yes.
It says reason is a little fact, Milord. Reason is kindly at the bottom, Milord. It says deed number 77, 31st December 2009 is the issue. Claimed plot does not match with the filed verification, does not process the plot, not satisfied, hence rejected.
আমাদের কাছে এসছে তো লক্ষ্যতে, আগে ছিল হাওড়া ট্রেডিং ছিল, এখন আবার লক্ষ্য।
This is the first rejection by the prescribed authority.
This deed is whose deed? 31st.
When the applicant petitioner's deed, that is at page 80. Deed number 77 of 2010. Lokho Trade Links. If your Lordships kindly come to Milord to the schedule part of the deed at page 91. It started from page 90, continues at page 91.
Yes.
Kindly see, it says, my lord, LR dag number 368/423.
Because there is a mismatch.
Mismatch means kindly juxtapose if your lordships kindly come to 1101s. That is rejection order.
395.
It says 395 LR dag. So this, whether this deed was ever rectified or not, I do not know. There should have been a rectification of deed.
মানে এলার দাগটা বলেছে 368 কিন্তু ওইটা ওই পেজ 95 এ ওটা 395 পেজ এর মধ্যে টপ
395, my lord, at the bottom. Kindly see at page 110.
395
ওটাও দেখাতে হবে
DD there is no 1395. DD it says LR dag 368/423.
What was Mr. Basu's submission as regards that mismatch?
They are in the 126.
126. Page 126.
Now 125, the memo of appeal under section 54 of the LR Act. It starts 125.
Come to 126. Roman 2.
Roman 2 subsequently land as above was duly recorded in its name under LR Khatian number and LR 395 in place of RS plot 368 and because the land RS plot 68 also and so. But the deed, has it ever been rectified? It is a deed. May I pose this question to myself? When we get some wrong done in the deed, lordship knows, my lord, we go for rectification of deed.
Subsequent.
Subsequent means you are saying LR plot. How can LR dag number change when you are doing the deed in the year 2010? 2010 is the deed. In the 2010 deed, you are mentioning LR dag 368. You go for mutation and say it is LR dag 395. Authority says mismatch. In the memo, you says it is.
That has been said by the mutating authority, mismatch.
Yes.
I have shown you lordship at page 110.
No, that is plot number is 395 given here, which does not tally with the deed.
Yes,
schedule.
because this should have been RS plot, not LR plot. The dag which is mentioned in the deed as LR dag, it should have been RS dag. So there should have been a rectification of the deed, lordship.
Not necessarily.
Huh? If the RS plot does not correspond with the LR plot, it is mentioned specifically LR.
RS plot of RS record of rights.
180.
180.
(368/423). 423.
423. Now, whether
Schedule in the schedule.
whether LR record of rights. Where is LR record of rights?
There is no LR, my lord, here. My lord, I am
LR has not been annexed.
No, I am showing the deed. Then comes the deed in the year 2010. In the year 2010 comes the deed. Deed says LR dag 368 of 423.
Okay. It was taken. This RS Portia was taken after publication of LRA. You come to 181 left hand side. Hull. Got it? Hull.
It is, my lord.
395. 395.
Miller, I am not on that.
It is certified copy of RS.
Miller, I am not on that, Miller. I am on the point.
That means this plot was subsequent.
RS plot corresponding to LR. This is why you write.
Yes.
Nothing.
Bata
But no, not Bata. I am telling. But in the deed, you have written LR dag. Deed is a document of title. Thereafter come mutation. So, my lord, this is what, my lord, I have seen. My lord, from the record I am showing. In the deed, they have written LR dag.
Should I answer that point? Even instantly, it will be easier for my. Can you come to the earlier mutation? 101.
101.
8th of June 2010.
That was 368.
Kindly come 368 by 723.
Yes.
So this is our land. Now it is, if it is changed subsequently,
2010.
But
That was the Pata plot.
in your deed at page 91, it is 360.
Ilarda, kindly note this, Lordship. I am on that, Lordship. It is a very simple. My learned senior friend also knows this.
তারপরে ওটা রিনাম্বার হয়েছে
kindly see, this is also the original mutation.
সেম
No, original mutation, kindly see 101. It would be RS in place.
That is written here, 367 by 423.
Milord, there should have been a rectification of deed. Arey, you are writing your own deed.
মিউটেশন সার্টিফিকেট
ঠিক আছে, থাক, বস, চুপ কর।
সেটাই তো আমরা এক্সপ্লেন করে দিচ্ছি আপনি 120
Yes.
Right. Lordship, next, Milord, may I deal with the judgments, Lordship?
Yes.
Yeah. Milord, my first judgment I cited, Milord, that is AI 962, Milord, SC, Milord, 694, Milord. I relied upon para 1, Milord, 26 to 29, Milord, 33 to 35, Milord.
Yes, that you have given.
On the ratio, Milord, proposition that estate and segregation of land, between that I am paying rent directly to the state, there is no intermediary, I am not an intermediary, it will not do. It is a proposition, Milord, based on Article 31A. Next, Milord, this judgment, Milord, I have cited, Milord, that is 2023 SCC Online Cal, Jitendro Investment Private Limited.
2023.
Non-agricultural tenant stands vested under estate acquisition. And this is one of the propositions in this particular judgment.
2023
SCC Online Cal P568. Milord, I had handed over, I am handing over again, Lordship. I am handing over, Lordship. The paragraphs, Milord, proposition is, Milord.
You have.
I am handing over, Lordship. I am handing over.
No, did you give it to us earlier?
I don't remember, Lordship.
Achha, para?
Paragraphs, Milord, 2, 3.
Yes, it was handed over.
2022 to 25 and Milord 27.
Paragraph 2, 3, 2022 to 25.
No,
and
22 to 25
and
27.
এই ফাইলে দেখুন না, এই জাজমেন্ট যদি দিয়ে থাকে আর নেব না, সপ্তাংশু বাসুর যে জাজমেন্ট গুলো রিলাই করে
এটা দাও তো।
Your judgments you gave us copies.
I will hand over to Lordship in a compilation.
Acha. Now then how he will deal with them?
I have already.
Already.
Argument complete.
The judgments by them I have distinguished, Milord, here and now. Milord, this judgment is on proposition, Milord, the circular issue, page 136, cannot be retrospective by nature. Milord, 2022, lekho, Shubho lekho. 22 volume 20 SCC. 2022 volume 20 SCC 996. Paragraphs, Milord, 1, 30 and 34.
Yes. Whereas 1, 30
and 34, Milord. Proposition, Milord.
circular cannot override.
Cannot have any retrospective effect, Lordship. Toraj Lakshmi Tada. No sellable right, Milord, this is another 2000 on the proposition. Retainer does not have any sellable right. Hence, title does not pass on to the purchaser. 2003 volume 9 SCC. He's a post-vesting purchaser, we considered it.
2003 volume 9 SCC.
2003 9 SCC 525. Paragraph, Milord, 16. 9 SCC 525.
No better right can be given.
Lordship.
No better right can be given.
Lordship.
Yes, para.
Para 16, Lordship. Tarumuni Mondol and others. It's a division bench judgment of our Honorable Court. 2006 SCC Online Cal 243. Proposition is, my lord, vesting under estate acquisition is total. It has nothing to do with LR Act.
No.
Concede করছিল পরে
Amendment.
conceding this.
Hey, amendment.
Paragraph.
Miller 17 and 21.
Yes.
Millard, I referred to one of my arguments regarding amendment to the preamble, Millard, of Millard Estate Acquisition Act. This is the amendment of 1961, Lordship. That part which includes all other persons. That part, Lordship. May I respectfully hand over, Lordship. Now, my lord, this is Lordship's celebrated judgment. Lordship is also well aware of, my lord. Ratnagiri judgment. That is 9-4 SCC 453.
Yes, citation.
My lord, 2009 4 SCC 453. It is only after this judgment, my lord, that explanation 2 has come into play, because this judgment said that any subsequent development, even by a retainer, cannot be destroyed by you. So after this judgment came the explanation 2 in the Estate Acquisition Act under section 6. Now in para 14 of this judgment, what does the Honorable Apex Court say, my lord? Huh? Ratnagiri? Oh, sorry, my lord,
I think
9-4. Oh, I handed over.
The paras that
Lordship, may I, my lord, read out only para 14?
Yes, yes.
The High Court was of the view that the proviso to section 6(3) does not give a right to the state government.
Yeah, just a minute. আরেকটা কোথায় আছে? সাহেবের মধ্যে আছে। কোন একটা বের করে দাও।
Yes.
Miller, may I read out para 14, my lord? My lord, the High Court was of the view that the proviso to section 6(3) does not give a right to the state government to revise any order passed under the main part of section 6(3) in view of 1955 Act. In other words, the High Court was of the view that is, the lands are allowed to be retained by an order of the state government under Section 6(3) of 1953 Act and was below the ceiling limit, then in view of Section 14Z of the 1955 Act, the power and the proviso to Section 6(3) of 1953 cannot be exercised by the state government. We regret we cannot agree with this view. In our opinion, the power and the proviso to Section 6(3) Act continues with the state government even after the enactment of 1955 Act or Section 14Z Act. There is nothing in 1955 Act or in Section 14Z thereof which states that on its enactment, the power of the state government under the proviso Section 3 shall cease to exist. It has no impact. LR Act does not have any impact on Section 6 of State Acquisition Act, my lord. The next judgment, my lord, 1997, my lord, 5, my lord. This is Orun Basu, my lord.
1997.
5 SCC 317. Okay. Did I hand over, my lord? I don't have a copy. Orun Basu.
5 SCC. नहीं दाओ
1997. 5 SCC 317.
Yes, yes, we have.
My lord, only para 6 may I, my lord, rely upon lordship. Para 6, my lord. It is then contended that by operation of Section 3A of the West Bengal Land Reforms Act 1955, the non-agricultural land does not stand vested. We find no force in the contention. What is vested under Section 3A of the Land Reforms Act is the tenancy right in a non-agricultural land and not the proprietary right. Proprietary rights having been abolished by operation of Section 4(1) of the Act, Section 3A of the Land Reforms Act in this regard has no application. It is then contended that direction so and so. So, Miller, that is my contention, Miller, respectful contention. The proprietary rights of a land which has already stand vested through the intermediary, a person who is claiming under him, that is definition of non-agricultural, cannot subsist. Now, my lord, distinction, my lord, of the judgments, my learned senior friendly has cited. First is Addoma, my lord. Addama, that is 2018, my lord. SCC, that is 2019 2 CLJ 582.
Just. তোমার কাছে 2023 SCC ওই এটা তোমার কাছে আছে তো এটার প্রফিট
This is by a coordinate bench of our honorable court.
Mr. Galif, you have given us 2 copies of that Jitendra investment.
Yes.
Addama,
my lord. Lordship, my lord, Addoma complex. This judgment, my lord, it is by coordinate bench of our honorable court, and I am also before your lordship a coordinate bench.
Which is the citation?
That is, my lord, 2018 SCC online cal. Or, my lord, if your lordships, my lord, want to go by this CLJ,
2018 SCC.
19 to CLJ.
Yes, yes.
Here, my lord, my only respectful submission with this judgment is that it has not taken into consideration Arun Basu 1997 5 SCC 317 and EIR 1962 Supreme Court 694.
yeah.
1962.
Orun
Which
Basu
that is Orun Basu, that is one. And second is the one I cited on Article 31A, that is EIR 1962 SC 694, which I have cited, lordship, at the very outset. These 2 judgments were not taken into, my lord, consideration. Milord, next judgment, Milord, Ovijit tie-up.
Yes.
Ovijit tie-up.
Hmm.
2023 SCC Online Cal Milord, 3064 Milord. Here, Milord, one of the distinctive features which stands on a different footing from the case we are dealing with, Milord, is here it was from Bagan to Karkhana conversion. So Bagan, Milord, is included in the definition of home state. So here conversion was from Bagan to Karkhana, and status of the Milord, this petition was shown as Sthitiban. Rayat is Sthitiban. Here is Boshut Rayat. So he was. Lord, if your lordships, yes, here I have gone through, it is lordship, Milord, it is stated here that original owner was holding the property as Rayat, which would be evident from the entry in record of rights. It is, Milord, I am with the SCC online edition.
Oh, I see.
And it is, Milord, it is paragraph 3, Milord. The sentence starts with, Milord, lastly, Mr. Mukherjee submits that the original owner was. Lastly, Mr. Mukherjee submit that the original owner was holding the property as Rayat, which would be evident from the entry in the record of rights to have been shown as Sthitiban and having transferred the land to a company much before coming into force of Act of 1953. So Rayat is Sthitiban. That means he was the original one, was a Rayat. Hence heritable transferable. Here it is claiming to be Boshot Proja on the basis of circular telling it is non-agricultural tenant. It's not a Rayat. It's a fetter under section 4C, 4 Milord, clause C of. So he was a Rayat and Sthitiban. And secondly, Milord, distinctive feature is, Milord, the judgments which I have cited, Milord, that is 1997 and this AI 1962, Milord, all were also not taken into consideration in Ovijit tie-up. Now, Milord, last judgment which my learned senior friend has cited is Juhi Finales. Milord, in the Juhi Finales, Milord, this particular judgment went up to, Milord, Honorable Supreme Court. Supreme Court dismissed the SLP, and thereafter, upon dismissal of SLP, the revision is pending before this Honorable Court. Now, what does Juhi Finales hold, Milord? Juhi Finales, our division bench hold, Milord.
SLP dismissed?
Yes, SLP dismissed. I am telling that I am not suppressing. Juhi Finales is distinctive feature.
Revision pending means before Supreme Court.
No, review we have pending. Doctrine of Major. Review before the lordship. Milord, distinctive feature from Juhi Finales with the present one is, in Juhi Finales, Milord, there was a rule for noting in the record of rights that it was a retained land. Here, although my learned senior friend has taken an argument.
Rule 4 of what?
Rule 4 of estate acquisition rules. Retention part. Here, my lord, my learned senior friend has taken
So it was recorded as
rule for noting was there, that is a retained land of the intermediary. So, my lord, juxtapose, my lord, upon placing this particular ratio of the judgment, if I may, my lord, recall the argument of my learned senior friend, he on one hand says, this particular land of my client is not within the purview of Estate Acquisition Act, since his seller vendor was a non-agricultural tenant. In the same breath, he says, it was a retained land of my vendor. So if it is retained land has to be a vested land. It is upon vesting the right of choice of retention comes up under section 6.1 followed by section 6.5. So the argument is self-contradictory. Choice of retention, because our High Court says it is choice of retention, not right of retention. So choice of retention as contemplated under section 6, subsection 5 of Estate Acquisition Act is with respect to the vested lands. Vesting complete, Bikrayat comes. I want to keep these lands. So if the argument is that the purchased land is outside the purview of Estate Acquisition Act, then question retention does not come. But the argument is, if it is retained land, then question outside the purview of 19 does not. This is self-contradictory. So here, my jui finales, it was a retained land of the owner, and rule 4 noting was there in the record of rights. Second, my lord, 1997-5 Arun Basu was not taken into consideration in jui finales. Jui finales 2009-4 SCC has not been taken into consideration. And my lord, the estate argument under Article 31A, that is EIR 1962 SC, was also not taken into consideration.
EIR 1962.
Now, my lord, last leg of my submission, my lord, went up to Honorable Apex Court. Apex Court dismisses, comes back, state files a review pending. My lord, this one-line order, special leave petitions are dismissed. It does not act as a doctrine of merger. Norohari judgment.
Kodai distilleries.
Yes.
Concede.
Eh?
Concede. One line, not much.
My book, though. (2023), my lord, 7, my lord, SCC.
For what?
Page
2023 7 SCC 740, my lord.
2023 7 SCC
740, my lord.
Very good.
My lord, paragraphs, my lord. Only one paragraph I will, my lord. Respectfully, my lord, refer to, my lord. Para 35, my lord, placitum, my lord, B, my lord. Para 35, my lord, placitum, B, my lord. While the conclusion of the said judgment is not relevant to the present case at hand, however, the reasoning behind coming to the said conclusion, in our opinion, has bearing on the present case. This court, in the above mentioned case, while holding that a review is maintainable even after the dismissal of special leave petition, observed that a dismissal of special leave petition by way of non-speaking order does not attract the doctrine of merger. So still now I am before your lordship, my lord, a bench of coordinate strength. There is no Supreme Court in between so far as jui finalis is concerned, lordship. My point in citing this is only for because of this, my lord. There is no intervention in between of Apex Court, because doctrine of merger does not lie. Still now we are governed by the division bench judgment. We SLP dismissed without the speaking order, review pending. So still now we are by the lordship. So my point in this glossary, last I will hand over this. This Stitiban. This glossary is a part of BT Act, Lordship. Kindly sees, Honorable Justice Milord, Chatterjee was referring to permanent settlement. No. Riot settlement is of different types.
Mr. Basu placed class on Usha Ghosh. Have you gone through that?
Lordship.
Usha Ghosh versus Robindranath Das.
Proposition?
AIR 2005 Calcutta 190. All right, what you're showing here?
Milord kindly sees the relevant part I have handed over, Lordship. Riot. If it is fixed rent, not paginated. 592 is the pagination at the bottom.
593.
592, Milord, I am on, Lordship.
592.
Kindly see at the top, Milord. Riot. If it is at fixed rent, the Bengali term is mokorori. অপরিবর্তনীয় খাজনা বিশিষ্ট রায়ত. If it is at fixed rate of rent, it is har mokorori. If it is settled, it is sthitiban. It is occupancy, it is dokholi shatto bishishto. So, Milord, these are different of rent paying. Settlement is sthitiban. Mokorori is not settlement. It is, Milord, mokorori is fixed rent. But sthitiban is settled. The glossary, Milord, part of BT Act, Lordship, which we find in Obhijit Tajab, Milord. He is a Sthitiban, Rayat is Sthitiban. So this gentleman purchaser, seller, was never a Rayat. Boshot Proja, claiming to be non-aggregate tenant. That too by circular of 1994. So, Milord, these are my respectful submissions, Milord.
Thank you. Mr. Vasu, we take it up another day. So we have a meeting. Mr. Galib, senior advocate. One and two ki
We have filed supplementary affidavit. One is WPLT 69.
No, in this we have not analogously heard, not being analogous.
That has not even opened us.
No, my submission would be, this is the point is whether the non-recurrent tenancy act coming under the purview or not. First, the foremost point, if your lordship of the view that the West Bengal non-recurrent tenancy act diets are not coming under the purview of this vesting under the Restitution Act, then my lord, that point will govern the other matter also.
But my lord,
Which
here,
according to us, my lord, already decided by your lordship.
here there is no resumption. Yes. But there is resumption order.
It doesn't matter.
Absolutely different.
It doesn't matter. If it is, I have no right. It is vested. Resumption will take place if the
those two matters
mill or
are
factory is
assigned to us. Those two matters also assigned to us.
that I
Part. He matters part.
same.
Sir, পরের দিন আপনি এটা রিপ্লাই দিয়ে ওটা স্টার্ট করে দেবেন।
একসঙ্গে কেন করব?
Yes, Mr. Basu, you conclude your argument.
But my view was that if my lord is deciding a question of law,
No confusion. We will decide finally.
no,
You
if you
conclude your
decide one,
you
that
understand. With our
that will automatically follow.
no, our problem is I will not be here for this.
I know.
This is the problem. We will forget. You finish it off. We will pass.
Probably I couldn't make myself clear. The point which I have already argued,
I understand
and I will
that.
reply, the same argument will govern. Only facts are difference.
Very good. The remaining argument you advance in 1 and 2.
As you lordship.
Supplementary affidavit will also be there. You can check it up in the meantime. And we, after you conclude, we will decide both the matters. We can take up that also for hearing.
I have been
My view
hearing,
was in both the matter is facts will be confusing to my lord. That's why
I have
I
been
was
hearing,
thinking.
my lord, the item number 3, my lord.
My
from
lord
the
is the
chief-
ultimate
my lord,
judge to decide.
You are not in item number 3.
No, I've been hearing, my lord, this fact, my lord, is absolutely different to 1 and 2.
Fact, I am not
Point
concerned.
of law, my lord, it will
You are appearing in which item?
item number 1 and 2.
For
Respondent number 8.
There is a private respondent.
you have given copy, Mr.
I have. I'm ready.
Sir. That again, Mr. Basu, how long will you take?
Any day at 3:30 except Friday.
No, that matter. Those two matters.
I have to deal with the entire facts. But conclusion is that. Conclusion that part. That's why I restrained myself from giving the facts to my lord so that my lord may not be confused. The matter is in my lord's mind, it will be difficult for my lord. No, এইটা
No, read this that.
এই ছুটির পরে দেখো জানুয়ারি ফার্স্ট উইকে
This matter. This matter.
3 matters.
No. This matter, the third one, which
Won't
Mr.
be able
Kalika concluded.
If we fix it on 15th, we have to reserve our judgment on that. Then in that case, the hearing of the other two matters becomes separate.
Kali, make it secret. This is my prayer, subject to my lord's presence. Let me, Kali, allow me to conclude this.
No, you conclude. We will record supplementary. We will file and everything. You argue on that date on 3. Please help us to do that.
No, don't embarrass me.
আসলে
Don't embarrass me.
ওটা জানুয়ারিতে
Grateful to you.